नो माय लॉर्ड, उनकी एलिगेशन की नहीं की गई, चूंकि
नहीं, बस ये पूछ रहे हैं. अच्छा, and now please go to what you said 2096.
Yes, sir.
Khan Sahib, you were referring to another provision.
Yes, sir. The others clause 6. If after inquiring into the matter, so this is very important, if, after inquiring into the matter, the council reports to the president that it is of the opinion that the judge is incapable of performing the duties of his office or has been guilty of misconduct, and that he should be removed from office, the president may remove the judge from office. So, sir, the council can only report if it has held inquiry into the matter.
Can you read 7 also?
7. A judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Meaning thereby, on the basis of a report which has been made after due inquiring into the matter, that only in that case, if there is a report in which he has been found guilty of misconduct after full factual inquiry, only on that basis he can be removed, cannot be removed for any other way. Otherwise, it is
going along with you. I just want to understand one thing. It's being conceded by the Attorney General that there was no factual inquiry. Now, moving ahead, what can we do? What can this court do?
That means that inquiry is that report by the Supreme Judicial Council on the basis of which he has been removed is unconstitutional, because Constitution requires.
I'm not asking for an argument. I'm saying what can this court do? What if I was to ask you, okay, what sort of order can this court pass? What would you suggest?
Declaring the inquiry, the report of the Supreme Judicial Council as unconstitutional, void, and nullity.
But suppose the allegations that you level were not true, then
what was it?
Suppose that the allegations that you leveled, one person is saying no, one person is saying yes. Now we must have a mechanism to ascertain who is telling the truth. I mean, we can't throw a coin in the air and decide on that basis. So there are two possibilities. I mean, you don't mind my saying so. Either the petitioner is telling the truth or is not telling the truth. There are only two possibilities. If, don't mind my saying so, if he's not telling the truth and he makes this allegation, and on that, and nobody ascertains, like you have alleged that nobody ascertained, and nobody ascertains whether his allegation is true or false, and is or whatever the order is set aside, surely this will not be proper. That's why I'm saying, how do we go forward now?
That is exactly the case. If your Lordship may kindly see that I informed the Chief Justice of
No, we understand that. They concede no inquiry was held. I'm saying, where do we go from here?
So therefore, the entire proceedings against me...
wo bhi ho gayi. Suppose, just for the sake of argument, we say, because we have to deal with these cases, it becomes precedent. Okay? Supreme Judicial Council, let's assume, did not do its job by inquiring into the matter. Correct? I think fundamental rights are available to judges as well. The due process and fair trial. By all means, hear it and then remove me. Because say this is false allegation you have leveled, you don't fit to be a judge, and not only made a false allegation, you went and made it publicly. If it was false, he should be removed. If it was false, he should be removed.
No.
No. If the allegation that you make now,
yes,
is established to be false after the inquiry,
yes,
should you have been removed?
Then can be yes.
Okay.
Then
no. Now I reverse it.
Yeah.
If after inquiry it transpires that the allegation that you leveled was true,
yes,
they may say you still should be removed because you went public, or no, you should not be. But your emphasis is on the fact that one way or the other inquire into the matter. Am I correct in understanding that? Now because you had leveled initially allegations without making anyone a party, so we wanted to hear what the persons against whom the allegations had been made, what would they say? They may come and say, yes, I did so, but there was nothing wrong in it, or simply say, yes, I did it. But the matter can't end now because they're saying, no, this is all false. So who will ascertain the truth of the matter?
The Supreme Judicial Council ought to have done that.
My position is.
Now your Lordship is...
Zara mein solution bhi bata dena sir. We're looking for how to solve this riddle.
इसका simple जवाब है sir. जैसे पहले, in some cases it has happened. एक तो ये है जो हमने begin with
हमें solution हम आपका point of view समझ गए, हम आपका केस समझ गए. अब हम करें क्या ये बताइए. What sort of order which should not, either then it will amount to the same allegation that you leveled on the other side. The other side will tomorrow complain and say, you never ascertained this fact, and you held that we've done this thing. So, we come up with a solution now.
Sir, my solution is yes. Let this order of the President and the report may kindly be quashed, and a commission may be appointed to ascertain the truth, so that we can cross-examine them, they can cross-examine us.
Commission, how, under what law will we do that?
This honorable court can always do so.
No, they can't.
To ascertain the truth about the matter.
No, it can't be remanded to the Supreme Judicial Council. Sir, is that a possibility or it's not?
It can be, yes. It can be, yes. It can.
No, I want your clear thinking on this.
After questioning the order of
Sub-Article 7,
there is one problem which I see.
एक Sub-Article 7 भी पढ़ लें. 209 Sub-Article 7. 209 Sub-Article 7 पढ़ लें.
जी 7 साहब वो 7 की बात हो रही है ना, तो उसमें है a judge of the Supreme Court or of a High Court shall not be removed from office except as provided by this article. Article क्या provide करता है? President can remove on the basis of a report. The report has to be based on inquiry. So therefore under clause 7
नहीं देखें ये तो admitted fact हो गया that no one ascertained whether the allegation was factually correct or not. That much is established from what I've been able to understand. Unless somebody says, no, it's not been established. I don't think even Khwaja Sahab, पूछते थे Khwaja Sahab कहाँ गए? Was the one way or the other, whether the allegation was true or not, was it been ascertained or not?
It was never inquired into, it was never ascertained, and if that part of the order would
how do we go forward then on this?
May I very respectfully submit?
Because both can't be telling the truth.
No, quite right. May I very humbly submit, my Lord? The order itself may have two components, although they are mixed up. As far as I am concerned, they are mixed up in the sense, one is with respect to the public speech that was made. Whether the public speech that was
made. That's a separate aspect.
This is what I'm saying.
That may in itself be such a grave crime that you remove him.
No, I'm making a
or nothing implied in the order is the fact that you've leveled such serious allegations against some people
which cannot be sustained because no inquiry was held. That portion.
What is the solution here?
May I very respect, this is what I was saying, Madam. May I very respectfully submit the order itself is composed of these two components. One is that a public speech was made. The other is that there was an allegation made or there were some assertions made which were not inquired into, and that was also held against the petitioner. Now that portion cannot be held against the petitioner so far as the STC order is concerned because that was never inquired into. We are only then left, as far as this list is concerned, only left with the question whether the public speech that was made was
नहीं देखिए उसका बड़े implication होगा. I think let's live in the real world. The entire eyes of the nation are before us. There are 2-3 constitutional offices involved. One is at stake is the independence of the judiciary. If I'm sure you will also agree that no judge should be removed without cause. I'm sure you will say that.
Yes, right. That's true.
That's one aspect. The other aspect is there's another constitutional body involved called the Supreme Judicial Council. Now, the Supreme Court should not interfere in the work of another constitutional body unless there is something so manifestly unconstitutional or unjust. What Mr. Hamid Khan Sahab is saying is there was no inquiry held, and you are conceding it, and the Attorney General is also conceding it. Needless to say, if the statement made was false, he also concedes that the judge should have been removed. Now, the third issue is the Supreme Court itself. We are hearing this case. Now the question arises, what sort of order we can pass in such circumstances? And I think there's an interconnected, where is the Attorney General? Attorney General, where is he?
अलर्ट मैं ऑफिस से चेक करवा लेता हूँ ऑफिस में
बुला लें अगर उनको.
खान साहब जरा ये ओपिनियन तो पढ़िए पेज 70 पे. ओपिनियन ऑफ द सुप्रीम जुडिशियल काउंसिल.
Yes.
पेज 70 पे है.
70 पे. Yes. Conclusion, sir. This council is unanimously of the opinion, kindly see here, that in the matter of making his speech before the District Bar Association Rawalpindi on 21/7/2018, Mr. Justice Shaukat Aziz Siddiqui, Judge Islamabad High Court Islamabad, had displayed conduct unbecoming of a judge of a High Court and was thus guilty of misconduct, and he is therefore liable to be removed from the office under Article 2096 of the Constitution of the Islamic Republic of Pakistan. 2096, which says you inquire into the matter, which was never done. The other portion of this, your Lordship may find very relevant, is on page 49-50, where they decided to dispense with the inquiry.
इसमें सवाल इसमें ये पैदा होता है, ये सवाल है कि सपोज एलिगेशन दुरुस्त है, सपोज क्या ये जिस तरीके से एलिगेशन बयान की गई हैं, जिस तरीके से तकरीर, क्या ये एक जज के लिए मुनासिब था? ये तो ओपिनियन उनकी ये थी कि चूंकि ये कर नहीं सकते थे.
सर इसमें हुआ ये, there was only one hearing in camera done, nothing else was ever.
ये तो डिनाइल नहीं आपकी तरफ से कि तकरीर हुई थी.
जी
तकरीर हुई थी, ये डिनाइल तो नहीं है.
नहीं
वो ये
तकरीर का डिनाइल नहीं.
नहीं सर, तकरीर का डिनाइल नहीं.
But देखिए, there are two kinds of speeches, ना? I mean, is a judge not allowed to make a speech?
Yes.
I think we should not forget the facts. The fact is not making of the speech. If it's making of the speech, then probably half the superior judiciary will have to go home, because how many judges have made to the Bar Council's speeches? I mean, these are not too. So
that speech was made before a bar is.
No. So it's not a question of mere making of a speech. It's the content of the speech. I think both go together. Now it depends what I say. If I say there should be, I go and tomorrow I make speeches, independence of the judiciary, this, that, the other, fine. I may even canvass a view which is different. But if I make allegation against someone, so I think you can't disconnect the two things. It's the nature of the allegation. Because I would say if otherwise, then we will have to read that Article 19 is not available to judges.
Yeah, that's what
I mean, okay, you may not agree with the judge's point of view, fine. I mean, but you remove him on that ground. The code of conduct doesn't say you can't make a speech. Mm-hmm. So on it, I don't think there's anything wrong per se in making a speech. Now, if you make some speech and you launch a vicious attack or loaded attack or whatever you want to call it, that we cannot disconnect with it. We have to see it together. I mean, I can't just say, oh, making of a speech. I mean, making of a speech is your right. Anybody's right.
And
I mean, it's not
District Bar Association.
By the way, you may be interested to know the United Kingdom which is so conservative. Judges give interviews. I mean, House of Lords. I mean, you know, those restraints have far gone, and judges of the American Supreme Court, as judges of the Supreme Court, Justice Stephen Breyer and Justice Scalia's debates,
all make public.
Debates were pretty vicious on various law schools they were given. So let's connect it with the speech. Now, nobody's taking us to the next level. What do we do? Can we personally ourselves inquire into the matter?
Sir, one thing which I just want to point out, there were a number of speeches made by Justice Kiani which was published.
I agree with you on that.
Very clearly.
You know, I agree with you. It will be, I think it is connected with the content.
Yes.
भाई अगर आपने बिला वजह ऐसे इल्जाम लगा दिए to another I don't want to use the word institution, but it's important,
yes,
whatever department of the government आप कह लें, जो भी आप कहना चाहें. So naturally it is not a nice matter, but if they are true, it changes, I think, the complexion of the matter.
Sir, page 70 अगर देख लीजिएगा, this is
solution मैं आपको ही नहीं बता रहा.
नहीं सर, solution तो ये है कि इस वक्त ये जो order है president का based upon the report of the Supreme Judicial Council need to be quashed.
देखें, Hamid Khan Sahib, it's not so simple. Then we'll be faced with an allegation that the Supreme Court threw Khwaja Saab's clients under the bus and saved one of their own. Again, we have to be very fair to both sides because you made allegation targeting specific persons. So if we quash it, that effectively means that all that you said was true without an inquiry, one way or the other. Now, how can we, I mean, you know, what do we do then?
So then the answer can be, I'm just making a humble submission, that let this order of the president be quashed, let the report be also quashed, and let the matter be remanded back to the Supreme Judicial Council to hold an inquiry.
Can this order be passed?
I believe so.
हमें असिस्ट करें.
लेकिन अगर सुप्रीम जुडिशियल काउंसिल बगैर इंक्वायरी के रिकमेंड कर देती है रिमूवल ऑफ
okay, are you saying it's inherent in fundamental rights and due process?
Yes.
Power of remand. Can you remand the matter to the Supreme Judicial Council?
And that can be consequential on the requestment of the order. It can be.
Khwaja Sahab, आप क्या कहते हैं इस
There are
पे?
two ways.
नहीं, let's see. Khwaja Sahab is a senior counsel. Let's see what his view is. Can we remand the matter to the Supreme Judicial Council or we can't?
My Lord, may I very humbly make a submission? It cannot be done because now there is nothing for the Supreme Judicial Council to inquire into because the petitioner's tenure has already expired. He is no longer, it goes back, he would no longer be a judge to be considered for purposes of removal, which is the function of the Supreme Judicial Council. So it does not fall within the functions of the Supreme Judicial Council at this stage. This is what my very humble submission.
So what is the solution? None?
This matter requires the determination or not?
Let's suppose we, for sake of argument, don't take it amiss, that we set aside the order. That means that that's implied in the order that all that he said, the judge, when he was a judge, was true. So you are condemned. Won't you be condemned?
It doesn't imply that, my Lord.
Why? Then he'll say everything I said was true, therefore the order was set aside.
Yes. What he said, my Lord, so far as the allegations against specific persons are concerned, they came up for the first time before the Supreme Judicial Council.
No, he's been saying it from day one.
No, he hasn't. The specific allegations against persons, by naming them and naming the incidents also, they never figured in the speech, they never figured in the preliminary reply that was given to the Supreme Judicial Council. It was in the second reply, the additional reply that...
No, but one way or the other, why didn't the Supreme Judicial Council say something on it? They could have asked him, say it on oath,
Yes. What did the Supreme?
I don't know. I called you to cross-examine him. I don't know, whatever way.
I'll make a submission. What the Supreme Judicial Council did was, they asked for the then Chief Justice of Islamabad High Court for his reply on the allegations that were made by the petitioner vis-a-vis him, and he denied all those allegations.
But it's one denial.
I'm just making
one assertion.
Yeah. No, but more importantly, may I make a submission? I said that before also, and I'm trying to be as balanced.
See, you can't just say because he's Chief Justice, I believe him, and because he's a simple judge, I disbelieve him. That's no.
Now we come back to the speech itself. The sole ground on which the matter against the petitioner could have been sustained, this order can be sustained, is if this honorable court comes to the conclusion that that speech per se was sufficient for his removal because it came within the definition of misconduct.
Are you suggesting a judge cannot give a speech to a bar counsel?
No. What I'm making a submission, may I make a mistake? Irrespective of whether it was true or not what the petitioner said, irrespective of that, because it maligned the judiciary as a whole.
How does it malign the judiciary?
Let's go through the speech itself, if your lordship would. No, and it maligned the Army Institute, the armed forces.
He is maligning you.
No, not in the speech. In the speech, it is the armed forces, it is the judiciary. They are the judges of the Islamabad High Court.
Suppose the allegations are true, then what will happen?
Even then, the petitioner should not have gone public or made a speech before the bar.
Why?
He could have issued a contempt notice.
Why are you saying he should not? Unless you can specify some violation of some law, constitutional provision, or a constitute of the code of conduct of judges, you can't just say he should not have. You should refer to something because of this reason.
The code of conduct says something to
we refer to that provision which says that judge cannot give a speech to the bar counsel or
it's
whatever.
Not a question of giving a speech, it is a question of giving a speech which maligns the judiciary.
Exactly, it's the contents of the speech.
Or which maligns any institution in the country. That is
okay. Now let us
only that has to be held.
Please refer to the code of conduct. Code of conduct mujhe nikalne. Which provision are you relying upon?
But may I very humbly submit, my lord, I am not taking sides in this case.
No, I know.
Because your lordship is called on.
No, actually, yes. It's always beneficial to have a senior counsel like yourself.
I'm just
because we are just thinking aloud how to proceed.
Yes.
And we'll be next be calling upon the Attorney General as well. So, which possible misconduct provision can you bring him under?
There's one provision in the Code of Conduct, Hamza, which relates to public speech.
Article 2 up. Maybe you can read Article 2.
I'll read that and then I'll read Article 2 for your lordship, my lord, but I think there's another provision which talks about, it's number 5. Yes, it's Article 5. May I very humbly submit? If it is to be stressed, it will fall under Article 5, nothing beyond. I will come back to that also. Functioning as he does in full view of the public, a judge gets thereby all the publicity that is good for him. He should not seek more. In particular, he should not engage in any public controversy, least of all on a political question, notwithstanding that it involves a question of law.
It's not publicity he was seeking. He was, let's call him a whistleblower. Every whistleblower, you will say, is seeking publicity. What publicity he was seeking by this? You are assuming burden will be on the person seeking his removal to show that he was seeking publicity. It's premised on that. As a judge gets all the publicity that's good for him, he should not seek more. So then it will be you are seeking publicity. In other words, you can't address bar counsels. Yes, there'll be the media there. So what?
So, may I not engage in any public controversy?
No, it says least of all on a it's not the public, it says political question. Where is politics here? There's no politics here.
It states in particular, he should not engage in any public controversy.
So if
least of all on political matters.
Let's take the worst case scenario. If the institution he is in, there is corruption, he should keep quiet.
No, there is.
So what should he do?
He should be writing to the Chief Justice.
Okay, he says failed.
He should be writing to the,
failed.
And if there is somebody,
then what should he do? He should keep quiet about it.
If there is someone approaching him, he has the power. He can issue contempt notice to that person. If anybody dares to approach him, to influence him in any of his decisions.
There's corruption, for instance, not this case, we're giving a simple thing.
What I'm saying,
and his colleague is taking a bribe. He writes to the Chief Justice, he informs the Chief Justice, doesn't do anything. He gets frustrated. Okay? Maybe the frustration level comes to a point that I'll go public now. Okay? So, fine. You can, the person against whom he is alleged and himself, you can certainly hold him to task by saying, prove this allegation. And the other person who's alleged it will say, you made a false allegation, I'll show it. Which is exactly what's happened in this case.
But may I
so which other article can you rely upon?
This is the only article, I suppose, my Lord. There is an article which was invoked in the order itself.
Which one was that?
Kindly read second para of Article 2.
I'm going to read that. Right. Second para,
Second para of Article 2.
In the matter of taking his seat and of rising from his seat, he shall be punctilious in point of time, mindful of the courtesies, careful to preserve the dignity of the court, while maintaining an equal aspect towards all litigants, as well as lawyers appearing before him.
He should be careful to preserve the dignity of the court.
Yes.
Yes.
This is, my Lord, I think
you are saying it comes under this too?
Lord, what I'm saying is that these are the provisions which can be...
No, tell me which one.
My Lord, I said Article 5 and Article 2, subpara 2 also comes within that because, my Lord...
We have an advantage in having you before us.
Lord, I'm grateful for
the advantage is you are now well versed with SJC matters.
Lord.
Okay. The other SJC matters where you are proceeding again. One is finishing a complaint, right? You don't have to inquire into great details of every frivolous kind of allegation. You can just dispose it off, consign it to the record or whatever it's called. But where you proceeding against a judge, why you proceed against a judge? With a view to remove him. So you have to give him some... I mean, here you may be conflicted as a lawyer. I'm not saying conflicted in this case, because your contentions at other place may be different. You will say, establish this thing. Fair enough. The burden on whoever lies the burden will establish it or not establish it. It doesn't get established. Clean bill of health.
देखिए आर्टिकल 2 सब इसके सेकंड पैरा में लिखा है टू प्रिजर्व द डिग्निटी ऑफ द कोर्ट। जो एलिगेशन इन्होंने लगाई हैं वो तो डिग्निटी ऑफ कोर्ट के अगेंस्ट है, तो इसको प्रिजर्व कैसे करें ये आपसे इन्होंने एक तकरीर में कर दी। दूसरा तरीका आप बता दें कि कैसे कर सकते हैं।
उसका तरीका मैंने बताया ना, जो एलिगेशंस लगा रहे हैं व्हाट इज my lord, I am again, let me again reiterate, I am not taking sides. I am saying if it can be stretched, that speech and conduct in terms of that speech can be stretched, it could at best fall within these articles, and there is nothing beyond that. Article 5 or at the subpara 2 of Article 2. And this is for the honorable court to decide whether that speech, irrespective of whether it is based on truth or otherwise, comes up to that standard of falls within this mischief or not. That is all. As far as the inquiry part is concerned, that did not take place. So they were, and those specific allegations are not there in the speech. The order itself, when we read page 70, we read the conclusion, it is basically focused on the speech itself, which is said to be the reason why the removal is being recommended. It's not the question of any other issues that were raised there, because they were not inquired into. Yes, to the extent of the Honorable Chief Justice, the reply was sought, and that reply came, and whatever the Honorable Chief Justice said was against what the petitioner was contending.
Did the Chief Justice, was he examined?
No, he gave a letter. So it's all a question. If this is a matter which goes on to inquiry, then yes.
But then it will mean that there must be a standard why you are believing the Chief Justice and disbelieving a judge.
What I'm going to saying is going back to the observation.
Is it the status which?
No, not at all. Not at all. It was just, I am not even supporting that. I am not supporting that because the Honorable Chief Justice said something, therefore believe him and not believe the other. I'm saying if this Honorable Bench comes to the conclusion that in this matter, irrespective of the contents of the inquiry itself, the speech itself, and that it was made publicly addressed to a bar association, which was then, this is fine, this is all right, this does not amount to misconduct, then the order that this Honorable Court has to pass, the way to move forward, is to exonerate him of the charges of making a speech which does not come within the ambit of misconduct. It does not imply that whatever he said was true or that it necessarily needs to be inquired.
If you read the order, it is 39 pages of the order.
Yes.
Content is there. If there was no content there, I mean, I would find it very strange that the mayor making of a speech.
I have submitted, my lord, that in the order itself there is a mixture of the presumption that what was being said by him in terms of allegations were not true, without an inquiry. I've already said that is part of the order itself. Okay. What the conclusion would be then that this particular list would come to an end with the petitioner being exonerated of the charges, the order being set aside, the recommendation being quashed, and he gets whatever he gets. But beyond that, if this Honorable Court wants to go into whatever the list may नहीं होगा, it has to go out of this list.
Khwaja Sahab, this nation has suffered enough. Now, it's not a question of granting relief to a particular person or withholding a relief from a particular individual. As far as I'm concerned, that's least of my concerns. My concerns are the integrity of the institutions. If the allegation level is true, I mean, the nation wants to know the truth of the matter. This person is telling the truth or that person is telling the truth. You say, no, forget it. Leave it aside. It's not a small matter of a small office holder post. It's a institutional matter. Let me ask you very candidly, as a senior lawyer, would you not want to know the truth of the matter, that the petitioner is telling the truth or your client is telling the truth? Just as you have invested your life in this profession. Yes, would you not want to know the truth of the matter?
This is exactly what I'm saying. I am with your lordship on that.
How do you get to it?
What I'm saying is that not in this list, not in the case before
how do we do it?
That your lordship takes suo motu action or takes some other action, but not it cannot be.
इनकी एक तजवीज़ आई है कि send it for review, remand it to the Supreme Judicial Council, that Article 209(7) was not complied with, and 205 and 6 all use the word inquiry, and 7 says you cannot remove it unless you follow the procedure. So that was not done. Without this court determining it, could the Supreme Judicial Council re-examine it and determine it once and for all whether, I think the nation needs to know whether the allegation is true or false. Leave aside your interest and his interest. There is an interest of the nation. You come from an institution which is paid out by the public exchequer. The petitioner comes from an institution which is paid out of the public exchequer. These institutions are not for your personal benefits. They are there to serve the people. So what do we do with it? People will make fun of it. What have you come up with? Result? Who was telling the truth in this matter? Because the truth is diametrically opposed. He's saying one thing, you're saying the opposite. It's not a question of variation of the truth. He misunderstood me, I meant this. Then we could have maybe reconciled both versions. तो ये जरा बताएं, इसको solve करें.
जैसे गुजारिश की, what my learned friend has said, if he has proposed, if he is sticking to that the matter can go back to the Supreme Judicial Council.
Can it?
I see a legal impediment that the Supreme Judicial Council is not cut out, is not constituted, it's not part of the Constitution for the purpose of making an inquiry which does not involve the recommendation made to the President for removal or otherwise of that of a judge. That part of the function has already come to an end.
Are you then suggesting a complaint is filed against a judge? or as in this case, by the registrar, whatever you want to call it, without inquiring into the complaint, Supreme Judicial Council says he is removed, recommends to the President, remove him. That's it, end of story.
Oh, the petition is here for the purpose of getting it quashed precisely for this reason.
नहीं, quash की बात नहीं आएगी. I'm saying that is the one person, but this is not a matter of one person, it's a matter of the independence of the judiciary, which the people of Pakistan have invested into it. They're not interested in a judge serving or not serving. This matter has gone into the public domain now. It has to be, the public has to be satisfied one way or the other. Who was telling the truth? Well, truth doesn't matter anymore. I keep emphasizing on truth. If he's truth, I think all the maslas will go away.
No, just as it was open.
Aren't you personally interested just to know?
No, yes. May I make a submission?
Burning inside you.
But not within the framework of law, within the framework of constitution, yes. We all want to know the truth, absolutely. But we have to remain within the frame. I do not see
which provision prohibits such an order. I'm just thinking aloud.
ये जो केस है आपके पास
नहीं ये ऐसी जनरल बात कर रहे हैं. अगर एक और कल को केस आ जाए, कंप्लेंट हमारे पास पर्दे नहीं बहुत सारी पड़ी हुई हैं, आती जाएंगी, मुझे कोई जज नहीं पसंद है, मैंने कहा चलो हटा दो इसको, सारे हमारे सुप्रीम जुडिशियल मेंबर्स अग्री कर लें, हाँ हटा दो, कोई हम इंक्वायरी करें कुछ ना करें, आपको बस खत्म हो गई बात, अब कुछ नहीं कर सकते हैं.
पिटीशन आती है, एक पिटीशन.
अगर देखिए एक बात है substituting your opinion for someone else, that's a different matter. The other is inquiring into the matter. Even a murderer has committed murder in front of everybody, you still have to go through the process. I mean, even if someone commits murder right in front of 100, 200 people sitting in this room, we can't just say hang him. No, we'll have to frame a charge, we'll have to bring witnesses, we'll have to give an opportunity for cross-examination. Total waste of time, you will say. Yes, that's what rule of law means. Total waste of time. Sometimes it amounts to that. I'm just trying to, each decision creates a precedent. So where should we go now from here?
As I keep saying, my lord, the order gets quashed if dishonorable bench comes to the conclusion.
Then the nation will hold us accountable.
Necessary, notwithstanding the allegations made.
If you have finished, can we request the Attorney General? Huh?
Yes.
Okay.
I made my submission.
Have you understood, because you came in late?
From what
let's just quickly recap everything. The petitioner made allegations in a speech to a bar. One is, you shouldn't speak to the bar at all, end of story, go home. The other is that the speech was so, whatever, it was not pleasant for someone or the other, and nonetheless it was made. Now the content is either true or false. It is admitted on all sides that the Supreme Judicial Council did not inquire into the matter. The word inquiry, Khan Sahib has said, is finds mentioned twice, again in 2096, and 2097 says you can't remove it unless this. Okay? To proceed further, you have to inquire into the matter, not to finish a complaint. If the complaint was consigned to the record, that's not the issue. But when you are proceeding against a judge, then Khan Sahib has said, where is my due process? Where is my right to, if everybody comes before me asking for right to fair trial. Now we come to the situation, where do we go from here?
And the most important thing is that the allegation has been leveled against the institution, which is more important as far as I am concerned. इसकी तहकीकात होनी चाहिए या नहीं होनी चाहिए, सवाल में उड़ा.
और एक चीज और, ख्वाजा साहब has also said one more thing, something important. He said once he's been removed and he's attained the age of superannuation, the matter ends. Now, we were hearing some other case.
Yes.
The same issue came up there also.
So, my lord, As far as not following or not conducting the inquiry is concerned, that is contrary to law, and that to my mind would be malice in law, and therefore Article 211's ouster would not apply as far as this petition is concerned. Which ouster? 211, sir. Article 211.
What does it say?
Bar of jurisdiction.
Bar on jurisdiction, my lord.
The number of judgments you said.
So I think that's quite settled. So if the inquiry hasn't been followed, on the basis of it being there being malafide in law, Article 211 does not apply. Therefore, this court would have jurisdiction.
Malafide in law.
No, but malafide in law is basically if the process is not followed. If what the law or the constitution requires is not followed, it is malafide in law. Not in fact, but in law. So because if that is so, then this court has jurisdiction, so the court can proceed. The court can look into the movement.
We are not a substitute for the Supreme Judicial Council.
Of course you're not, but now the question...
We can't say, okay, now please come and give oath and give it on statement, will cross-examine.
No, this is jurisdictional question. This is jurisdictional question. You're not going to inquire into the matter while sitting as a court. The Supreme Judicial Council's, it is Supreme Judicial Council's remit to look into that matter, but I am just only saying that this court has jurisdiction to hear the petition if the inquiry has not been conducted, 209, and the procedure has not been followed.
That bridge.
So yes. So once that is done,
where do we go from here?
Once that is done, now one fact which was alluded to, and there is a judgment, a two-member bench's judgment in Afia Sheher Banu Zia's case, PLD 2023 Supreme Court 510, wherein the two-member bench has held that if a judge has resigned or has retired, the proceedings, if while he was on the bench had commenced before SJC, they would abate. Now, the federal government, I had in another matter stated before your lordship that the federal government intends to file an appeal against that judgment.
Has it been filed?
Yes, my lord, it has been filed. My lord, it has yet to be numbered. I hope it will be numbered today or tomorrow. Now, there are several problems with that judgment, and of course...
If the principle of that judgment is sustained, then it effectively cuts both sides. Then a judge who's been unconstitutionally removed can do nothing.
Now, so in
the meantime, he retired, for instance.
So in this case,
he attained the age of superannuation.
So in this case, the distinction also is that after the judge the petitioner was removed, he had essayed those proceedings before this court, and he had not attained the age of superannuation at that time. So that distinction being there, but that judgment needs to be revisited also by this bench or any other bench in order for the court to then pass the order of setting aside the Supreme Judicial Council's order in this case. Also,
yeah, I'm not clear with you. Are you saying that we should attach that case with this case?
I would submit so, my lord.
Achha. Okay.
And now, if the inquiry process has not been followed, and the allegation, now we don't know what
is remand permissible?
If, my lord,
if you are saying if Afia is sustained, then it probably may not be. Is that what I'm not understanding?
If Afia is sustained, then perhaps in this case, they may still have to, the petitioner may still have an argument to make, which is that he had not attained the age of superannuation when he had challenged the Supreme Judicial Council's order before this court. So there would be that distinction.
I think there is a fact is that the list in some form or the other was before this court.
That's right. So that's what I was alluding to. That if there would still be a distinction as far as this particular case.
If we accept this petition, what will happen? So we'll simply
two things can happen. If my lords accept this petition and simply set aside the Supreme Judicial Council's order without remanding it, then he would be treated as a judge who would retire.
We are also concerned about the allegations. What would happen to the allegations?
Suppose, with due respect to the petitioner and his counsel, suppose we set aside the order and he is laughing all that I said was false. Okay? Nation, I think I'm more concerned that every case we decide we have to keep half an eye out. That iska implication generally kya hoga? You may want to do something, but it may have wide ranging implications. The other thing is, doesn't the nation want to know one way or the other? What is the position of the federal government on this? Well, wouldn't you want to, as they say, get to the truth of the matter?
My Lord, so I just got called on short notice,
I know that's not fair.
But what I can state here is that now there are certain allegations which are made in this petition, and those allegations, from what I've understood while sitting here, have been denied.
Not some minor allegations, some serious allegations.
Those allegations have been denied, and now obviously this court cannot record evidence. Is not the forum for doing it. Is there a solution? The solution, my Lord, is that in order to look at the entire matter in totality, if Afia Zia is overturned and this matter is remanded to, the order of the Supreme Judicial Council is set aside and the matter is remanded to Supreme Judicial Council, then as far as the inquiry of these allegations is concerned, that perhaps is the only forum.
And then question arises that the man has retired. What will happen?
So for that purpose, you have to overturn Afia Sherbanu Zia. For those purposes, you have to first, this court has to overturn Afia Sherbanu Zia in order to cross that barrier and then go to
this case is slightly different. He was not retired at that time. That's right. He was still before the court. Now the question would still be that if the petition is allowed, what could be the consequence? Now if limited consequences जल्दी डिसाइड हो जाती है इनकी रिटायरमेंट से पहले तो मसला हल हो चुका
वो भी हो चुका होता, बट अगर फॉर एग्जांपल एक ये हो सकता है कि जी पिटिशन आप अलाउ कर दें एंड he is treated as a retired judge and thus entitled to all the benefits which a retired judge is entitled to. But if on a broader scale, so on a broader scale, then I think since he has retired and now that
is what's troubling me. Let's suppose a complaint is filed against a judge 1 month before his retirement. And the Supreme Judicial Council, without saying he is corrupt, Supreme Judicial Council, without inquiring into the matter, recommends to the President, reports, whatever, remove him. He's removed. Now, naturally, when he filed the petition, he's already stand retired.
That's right.
So I don't think the date would there be. He has got no way to vindicate his honor.
There has to be a way.
Basically, you are saying one way is no, too bad, whether the Supreme Judicial Council inquired into the matter or not. I mean, whether we agree with the findings of the Supreme Judicial, that's a separate matter. One is at least inquire into the matter. Okay, I may have a higher level of proof, another may be lower, but leaving those technicalities aside, basic inquiry has to be conducted of some form or the other.
Absolutely.
I mean, whether it has to be in accordance with the Qanun-e-Shahadat or...
No, it's the Constitution requires so. I mean, a judge cannot be removed without inquiry.
Are judges entitled to fundamental rights or not?
Absolutely. I mean, it is at the heart of independence of judiciary. Absolutely. Absolutely. At the heart of independence of judiciary has...
इसका solution क्या है फिर?
So इसका solution to my mind is...
आप कह रहे हैं कि इसको club करें उस केस के साथ?
उसको overturn करना जरूरी होगा because that would then settle the law. Because in this case, obviously, there was a substantial period of time when the petitioner was removed.
लेकिन बात कहाँ से कहाँ connect हो जाती है?
And his
nobody could have thought this would connect there.
About 3 years.
So if he had 3 years to a service left.
No, like I said, suppose he had only 1 day left.
Yes. So in that hypothetical,
I mean,
then obviously,
I don't think that's really crucial aspect.
So in that hypothetical, which my Lord has just pointed out, I think it is necessary that that point is settled. That the point is settled that even if he stands retired and attains age of superannuation, the matter can still be revisited by
because that delay we are accountable for in this particular case because it's proceeded so long. We can't fault the petitioner on that.
Oh, absolutely not. Nobody can.
So, कितनी hearings हो गई थी इसमें?
बेशुमार सर, many hearings.
हमने कितनी दफा सुना?
Last hearing was.
मैंने कहा आपका इल्जाम हम पे तो नहीं है, हमने कितनी दफा सुना इस केस को?
मैं आपको ऑर्डर शीट दिखाऊं तो
ये दूसरी दफा है, हम मेरे साथी याद दिला रहे।
But we are responsible for our seniors.
अक्टूबर 2018 में ये पिटीशन फाइल
2000
ना नहीं, वो क्योंकि वो पार्टी नहीं बनाया था ना, उसमें भी टाइम लगा। वो आपका कसूर था खान साहब, थोड़ा हमारा कसूर था मगर वो आपका कसूर था, मान लीजिए, क्योंकि आपने एलिगेशंस लगाई थी अगेंस्ट पीपल हु वर नॉट बिफोर, सो वी हैड टू गिव देम अ नोटिस। सो वो दैट गोज इन योर, वी डोंट एक्सेप्ट रिस्पांसिबिलिटी फॉर दैट। जी जी।
But the question that even shows that this was a case.
Wasim Sajjad Sahab, can we benefit by your acumen? Have you been following what we are talking about? What is your view? Can it be remanded to the Supreme Judicial Council or not?
But actually, I haven't studied this matter. I wouldn't like to make a comment without going through the studying it properly, because it's an important question. But I would say that the Supreme Court of Pakistan is the highest court, and there's nothing in the Constitution which prevents it from remanding the case back to the Judicial Council. But as I said, I would like to study the matter further. Once the matter is before your lordship also has the power to do complete justice under Article 187. So there's no impediment.
आपकी अपील कब लगी है?
My lord, it's been filed earlier today. I think it will hopefully be numbered today. And once it is numbered, I think it can be fixed whenever the office will fix it.
Point that you want to say at this juncture? Anyone, any of the council or?
This is one of the exceptional cases. Earlier cases, like Justice Shaukat Ali's case, there was a detailed inquiry held. And after that, the Supreme Judicial Council submitted to the President to remove him. There have been even earlier cases, Ikhtalafi Hussein's case, where inquiry was held. This is the first case of risk nature where no Supreme Judicial Council did not hold any inquiry into the allegations. So therefore, my submission is this goes right against the independence of...
No, can you cite those cases, the earlier cases, where inquiries were held?
One is Justice Shaukat Ali's case is PLD 1971 Supreme Court.
1971 Supreme Court.
Page 585.
585. And here you are saying the Supreme Judicial Council did hold inquiry.
Hold a very lengthy inquiry, some 80 witnesses and so on. So
recommended the judge's removal. And in the next cases, this is Justice Shaukat Ali.
Earlier case was Justice Ikhtalafi Hussein's case, PLD 1960 Supreme Court. Yeah, page 26 perhaps.
जी
अच्छा उसमें
नहीं वो पेज नंबर अखलाक हुसैन हम ढूंढ लेंगे, चलें खैर अगला वाला बताते हैं। कोई और भी केस है?
ये दो केसेस हैं जहां पर सुप्रीम कोर्ट जज वाज रिमूव्ड आफ्टर ड्यू इंक्वायरी। नाउ सर एक और बात, 1956 का मैंने कॉन्स्टिट्यूशन एग्जाम देखा है, उसमें कहीं इंक्वायरी की रिक्वायरमेंट नहीं थी एज सच, बट inquiry was held.
Which was that provision of 56 Constitution? Which article?
Earlier article was 128.
128.
60, under the 60.
Article 128, Supreme Judicial Council, which did not specifically mention the word inquiry.
It mentioned inquiry. Article 128 was in the same terms as Article 209. But I'm talking about 1956 Constitution. Under the 1956 Constitution.
किसमें नहीं था?
ये इसमें नहीं था अखलाक हुसैन वाले केस में, स्टेट वर्सेस अखलाक हुसैन।
नहीं, वो कौन सा आइन था जिसके आप जिक्र कर रहे हैं?
56 का।
उसमें नहीं था,
उसमें ये नहीं था कि इंक्वायरी जरूरी है।
उस आइन की कौन सी शिक थी?
उस आइन की शिक थी आर्टिकल 169। 169।
अच्छा, 169। अच्छा, इसमें नहीं था।
हाँ, उसमें
अब आप ये
I read that out.
No inquiry required. हाँ जी।
A judge of a high court shall not be removed from his office except by an order of the president made on the grounds of misbehavior or infirmity of mind or body if the Supreme Court, उस पर Supreme Judicial Council नहीं, Supreme Court ये function करते थे. If the Supreme Court on reference being made to it by the president reports that the judge ought to be removed on any of those grounds. ये article 169 था उसमें, और इसके बावजूद भी डिटेल इंक्वायरी की गई थी उसमें, और डिटेल इंक्वायरी
अखलाक हुसैन का केस था, तो 56 कॉन्स्टिट्यूशन वाज अंडर कंसिडरेशन और द 60 कॉन्स्टिट्यूशन
अंडर द 1956 कॉन्स्टिट्यूशन।
अच्छा, मगर उसके बावजूद भी इंक्वायरी हुई
थी। सो मेरी गुजारिश ये है कि दिस इज द फर्स्ट केस ऑफ इट्स नेचर वेयर ए जज इज रिमूव्ड विदाउट इंक्वायरी. It will have a repercussion for the future because judges of the Supreme Court has no other security available to him except that a Supreme Judicial Council makes inquiry into the allegations. If that is taken away from him, then he is left on the mercy of the person who alleges against him, whether he is president or whether he is any other person making a complaint. So therefore my submission is that a detailed judgment is required to give why inquiry is so necessary in cases where the allegations against the judge of the superior courts for which there cannot be any recommendation for removal without holding a proper inquiry into it and giving a statement of allegations. Even in the case of Ikhtalafi Hussain, there were 3 allegations, specific allegations made. Similarly, in case of Sheikh Shaukat Ali in 1971, specific allegations were made against him, on which inquiry was held. In here, no statement of allegations were ever given to the petitioner, and naturally,
और भी केस था ना वो खान साहब वाला
जी,
एक और भी केस था ना, वो रिपोर्टेड है या नहीं है?
ये दोनों केसेस तो
फजले गनी खान साहब का कोई उसमें केस चला था या नहीं चला? चला नहीं था
इनका,
नहीं चला सर, नहीं चला। नो सर।
खान साहब एक बात बताएं आप, इसके अंदर तो एलिगेशन डिफरेंट है शौकत अली साहब वाले में और इखलाक हुसैन साहब वाले में। यहाँ पर जो इंफॉर्मेशन की बात है, सब सेक्शन 5 ऑफ आर्टिकल 209, वो इंफॉर्मेशन की बेसिस पे, लेकिन यहाँ तो सुप्रीम कोर्ट ने खुद कॉग्निजेंस लिया है, तो यहाँ तो कॉग्निजेंस लिया है इसने, वहां पे इंफॉर्मेशन किसी पब्लिक पर्सन ने किसी ने कोई इंफॉर्मेशन तो नहीं दी है। तो इंक्वायरी उस सूरत में करी जाए जब कॉग्निजेंस लिया है कोर्ट ने, खुद लिया, रजिस्ट्रार ने दूसरा लेटर भेजा है, बिल्कुल उसकी बेसिस पे, तो ये चीज जो है यहाँ पे जरूरी है, इंक्वायरी बहुत जरूरी, जब कॉग्निजेंस सुप्रीम कोर्ट खुद ले रहा है,
और भी ज्यादा जरूरी हो गई है। जनाब ने बिल्कुल दुरुस्त फरमाया, और भी ज्यादा जरूरी हो गई है। हुआ ये था कि 1956 कॉन्स्टिट्यूशन में
तो ये केसेस में कुछ एक आध मेरे हिसाब से कुछ करप्शन का भी केस है इसका।
डिस्टिंग्विश, बट आई एम जस्ट सेइंग द प्रेसिडेंट अवेलेबल विद अस। गुजारिश ये है कि इसमें हिस्ट्रीज की ये है कि ना 56 कॉन्स्टिट्यूशन में विदाउट प्रेसिडेंशियल रेफरेंस किसी जज को रिमूव किया जा सकता था, ना 62 के कॉन्स्टिट्यूशन में ये हो सकता था, 73 कॉन्स्टिट्यूशन में भी नहीं हो सकता। फॉर द फर्स्ट टाइम 17th अमेंडमेंट में ये लाए गए थे, द काउंसिल ऑन इट्स ओन, द काउंसिल में ऑन इट्स ओन मोशन, ये पहली दफा 2005 में इंट्रोड्यूस किया कॉन्स्टिट्यूशन में कि इवन सुप्रीम जुडिशल काउंसिल विल हैव द पावर ऑन इट्स ओन, ऑन द बेसिस ऑफ कंप्लेंट अवेलेबल, कैन प्रोसीड अगेंस्ट अ जज ऑफ द। दिस इज द केस हियर, इट इज नॉट अ केस ऑफ प्रेसिडेंशियल रेफरेंस, इट इज अ केस विद सुप्रीम जुडिशल काउंसिल।
कैसे शुरू हुआ ये इधर में दिखाइए,
लेटर रजिस्ट्रार सर,
दोबारा ये बताएं कैसे।
सुप्रीम जुडिशल काउंसिल ने क्या अपने तौर पे ये उठाया या
वो किधर
या रजिस्ट्रार ने एक नोट लिखा, रजिस्ट्रार ने किस कैपेसिटी में लिखा, ये
अपने तौर पे ना कंप्लेंट है,
ये वो दिखाएं
रजिस्ट्रार ने किस कैपेसिटी में दी, ये भी देखना है।
दिखाएं क्या चीज है
उसको
39 पेज के ऊपर है ये, 39 पेज पे पैरा 3
2018 को रजिस्ट्रार ने
ये पेज नंबर 39 ऑफ द पेपर बुक।
जी सर, ये है सर यहाँ पर
अपॉन perusal of the note put up by the secretary of the council।
ये नोट किधर है, किस पेज पे?
नोट नीचे है सर दिया वो पैरा 3 में।
आपके कॉपी लगाई आपने? एक्चुअल
लगी हुई है?
जी कॉपी लगाई, इन्होंने खुद भी जो जवाब दिया है रजिस्ट्रार ने,
वो दिखा देना एक्चुअल नोट कहाँ है।
जी सर, ये 21/7/2018 ऑनरेबल मिस्टर जस्टिस सिद्दीकी एड्रेस।
नहीं पेज कहाँ है? पेज कौन?
ये पेज 39 पे सर।
नहीं ये तो उसका रिप्रोडक्शन है ना,
रिप्रोडक्शन है।
मुझ में एक्चुअल नोट दिखाइए मुझे।
एक्चुअल नोट हमारे पास तो नहीं है, ये हमें तो
ये डॉक्यूमेंट फाइल किए, इसमें क्या है सारे ये जितने
अब उन्होंने जो
ये सर 73 पेज पे एक लेटर है अरबाब मोहम्मद आरिफ साहब का।
जी,
कंप्लेंट अगेंस्ट मिस्टर जस्टिस शौकत अजीज सिद्दीकी जज इस्लामाबाद हाई कोर्ट, 31 जुलाई 2018 का है।
जी हाँ,
नहीं, I'm directed to serve upon you the enclosed। ये तो बाद में है ना।
कंप्लेंट जो इन्होंने रिसीव की है वो 23/7 की है, जो रजिस्ट्रार ने कंप्लेंट
वो मेंशन किया, उसको रिप्रोड्यूस किया हुआ है पेज नंबर 39 पे पैरा 3 में रिप्रोड्यूस किया हुआ है।
जी हाँ, बिल्कुल सही, एग्जैक्टली वो रिप्रोड्यूस किया। The note put up by the registrar and the transcript of the speech। नोट जो है हाँ, ये नोट on top of page 39 on 21/7/2008 Honorable Mr. Justice Siddiqui addressed District Bar Association Rawalpindi। During this speech he said
39 के शुरू में सर,
page 39 सर,
ये पैरा 238 से शुरू हो रहा है।
पेज 39 के ऊपर जो फर्स्ट पैरा जनाब देखिए।
नहीं वो तो एलिगेशन है ना
जी, एलिगेशन है।
अच्छा नीचे पैराग्राफ 2 से पढ़िए
सर, ये पैरा 2 on page 38
जी।
On 23/7/2018 the secretary of this council, registrar Supreme Court of Pakistan, submitted the following note before the chairman of the council, Chief Justice of Pakistan। ये वो फिर नोट 23/7 को रखा गया। On 21/7/2018 Honorable Mr. Justice Siddiqui
No, he was acting pursuant to a direction of the Supreme Judicial Council, or my lord has asked, Justice Jamal has asked that he did it himself. एक तो ना you do it. One is he does it, comes before the Supreme Judicial Council.
So it doesn't say so much, but it appears that there was some kind of a...
We will go by the Constitution. Constitution says the council on its own.
On its own.
Secretary is not the council.
नहीं तो
he may be complainant.
It may
he's part of the Supreme Judicial Council.
Maybe the council had directed him to do it. I don't know.
Nothing is on record, कोई चीज नहीं है। लेकिन ये
मतलब उसने अपने पर्सनल कैपेसिटी में दिया।
आप ये हियरिंग जो, अच्छा एक चीज बताइए,
आप जनाब पढ़ लीजिएगा,
कितनी दफा सुप्रीम जुडिशियल काउंसिल में ये केस लगा आपका? आप कितनी दफा सुप्रीम जुडिशियल काउंसिल ने आपको तलब किया?
एक दफा। Only on one occasion.
What happened on that occasion?
On that occasion, we said that please, in the first place...
No, you asked something, why were you called?
We were called to explain as a preliminary hearing before inquiry, and preliminary hearing hoti under the...
Was the petitioner alone or was he assisted?
I was with him.
क्या हुआ सर, बताएं क्या हुआ था उस दिन?
उसमें यही क्वेश्चन हुआ कि ये क्या स्पीच की है आपने? We made a speech which we...
नहीं वो ठीक है बस. So it was a casual, formal meeting. What charge frame हुआ आपके खिलाफ, क्या?
कोई charge frame नहीं है, कोई charge frame नहीं है. बल्कि इससे पहले
we may need to see the record of the Supreme Judicial Council.
जरूर देख लीजिएगा. कोई यहाँ भी कहीं रिपोर्ट में भी नहीं कहा गया कि कोई चार्ज फ्रेम हुआ है. रिपोर्ट में देख लीजिएगा ना, कहीं पर ये नहीं कहा गया कि मेरे खिलाफ कोई चार्ज फ्रेम हुआ, स्टेटमेंट ऑफ एलिगेशन दी गई जिसका मैंने जवाब देना था. नथिंग ऑफ दैट सर.
आपको कोई शोकॉज नोटिस नहीं हुआ? शोकॉज
नोटिस दिया.
वो किधर है?
वो शोकॉज नोटिस
74 पे. 74 of the petition.
ये जनाब पेज
42 पर रिप्रोड्यूस भी हुआ है जज,
पेज 74 पर
इसका ये तो वेरेस अच्छा नाउ यू आर ये पेज 75 पे आ जाइए ना, ये है ना
ये है जी पेज 75 पर. Now your lordship are hereby called upon to explain your conduct with regard to the following allegations which prima facie constitute misconduct on your part within the meaning of paragraph B of clause 5 and clause 6 of article 209 of the Constitution. You were, while addressing the District Bar Association Rawalpindi on 21/7/2018, have leveled the following serious allegations pertaining to superior judiciary and a state institution.
देखिए इधर तो क्वेश्चन ऑफ सीकिंग पब्लिसिटी नहीं एलिगेशन है,
ये नहीं है,
ये तो एलिगेशन वही है ना, सब्सटेंस पे जा रहे हैं स्ट्रेट अवे. इट्स नॉट अच्छा
making a speech and on the content of the speech actually. That ISI is fully involved in manipulation of judicial proceedings, including marking of cases to honorable benches. 2. That ISI personnel approached Chief Justice Islamabad High Court and asked him not to let Mr. Nawaz Sharif and his daughter come out of prison before general elections 2018 and not to include your lordship in the bench. And that Chief Justice Islamabad High Court responded that the bench will be constituted as per their desire. That your lordship claimed to even have knowledge of the person who conveys messages to the Supreme Court, that daily proceedings of accountability court were being reported somewhere, and that your lordship also knows the reason why the administrative control of Islamabad High Court as per statute was removed so that no judge could look into the proceedings, that your lordship was asked to give assurance that your lordship would give decision as per their request, and then references pending against your lordship would be closed. That if your lordship decided cases according to their desire, your lordship would be made Chief Justice Islamabad High Court by September 2018. Upon presentation of the transcript of your speech, Honorable Chief Justice of Pakistan had been pleased to observe that the allegations leveled in the speech had cast aspersion and maligned the superior judiciary of the country and berated its independence. It also implies some other national institutions. And the Honorable Chief Justice of Islamabad High Court was asked to comment upon the veracity of the allegations leveled against him. He was also asked to obtain from your lordship the material evidence available, if any, to be immediately transmitted to the office of the Chief Justice of Pakistan for consideration and appropriate action if necessary. In response, Honorable Chief Justice Islamabad High Court offered his comments by letter dated 29/7/2018, wherein his lordship responded that while a letter dated 24/7/2018 received from your lordship regarding allegations leveled against Honorable Chief Justice of Islamabad, his lordship has categorically denied all the allegations. The above act on your part amounts to misconduct as envisaged in the provisions inter alia of Article 2, 3, 5 and 9 of the Code of Conduct prescribed by the Supreme Judicial Council. One fact I want to bring to the notice, sir. At the time when these proceedings were initiated, proceedings were going on against Justice Anwar Kansi, Chief Justice of Islamabad High Court, before the Supreme Judicial Council for quite some time. I remember in another case when he sat on the Supreme Judicial Council and I objected. That was a case where I was counsel for Justice Farooq Irfan. I objected to his sitting on the Supreme Judicial Council on the ground that under clause 3 of Article 209, a judge against whom proceedings under Supreme Judicial Council were being
he was in the same matter or some other matter?
That was a question. They declined that.
I don't understand your contention. Are you saying, suppose
I'm disclosing, I'm stating facts.
No, एक second. Fact you may be stating, but you are making a legal implication out of the stated facts. Now, for instance, suppose the Supreme Judicial Council is legitimately convened to inquire about a judge. It may be used as a tactical ploy to file complaints against all the members of the Supreme Judicial Council and then say, oh, none of you can hear the matter. So merely that in itself is nothing relevant unless there's a direct nexus. You know, otherwise तो ये तो बड़ा खूबसूरत होगा. इनके भी खिलाफ कर दो, वो फेल ही हो गया सुप्रीम जुडिशियल काउंसिल.
मैंने ज़िमनन बताई कि उस वक्त ये ऑब्जेक्शन इसलिए लिया गया था कि जस्टिस अनवर कांसी वाज अंडर इंक्वायरी इन अनदर केस अगेंस्ट हिम.
देखिए खान साहब,
आप उसकी आप रिकॉर्ड मंगा लें. खान
साहब सॉरी, या तो आप इसको कोई दलाइल देना कानूनी आईनी, ये मुझे बात समझ नहीं आ रही है भाई. हमें नहीं पता कल कोई 50 कंप्लेंट फाइल कर दे सब जजेस के खिलाफ तो सुप्रीम इदारा ही खत्म हो जाएगा.
नहीं, वो इंक्वायरी वहां होती है जहां सुप्रीम जुडिशियल काउंसिल सेज दैट देयर इज अ प्राइमा फेसी केस for proceeding against him. There was a prima case which was going on, inquiry was going on.
How would that matter to him, to the petitioner?
How it
maybe he gets removed, both get exonerated.
मेरी बात मुकम्मल सुन लीजिएगा फिर उसके बाद.
हाँ बताइए.
हुआ क्या? ये जो फैक्ट्स यहाँ दिए गए हैं कि उनको खत लिखा गया था कि बताएं ये एलिगेशंस हैं, उन्होंने डिनाई किया. What happened? मुझे 11 अक्टूबर को रिमूव किया गया ऑन द रिपोर्ट ऑफ द सुप्रीम जुडिशियल काउंसिल. उसी दिन या उससे अगले दिन उनको एक्सोनरेट कर दिया गया फ्रॉम द चार्जेस ही वाज फेसिंग बिफोर.
तो सीरियस एलिगेशन लगा रहे हैं.
That the very next day, ये फैक्ट्स जनाब आप
I'm saying for the sake of arguments, if these facts are correct, what does it mean?
It means, sir, that वो चूंकि गवाह बन गए हमारे खिलाफ तो उसको उसकी जो एलिगेशन से उसे एग्जम्प्ट कर दिया गया.
नहीं, क्या वही कंप्लेनेंट दोनों केस में था या तो कुछ ऐसा नेक्सस जोड़िए ना.
ये बातें और है, मैं सिर्फ जनाब को बता रहा हूँ देखिए कि सुप्रीम जुडिशियल काउंसिल ने किया क्या. जब उन्होंने मेरी एलिगेशन को डिनाई किया तो उनको छोड़ दिया.
जहाँ तक आपकी बात सब देखिए, हम सुप्रीम जुडिशियल काउंसिल पे ऐसे उंगलियां नहीं उठाएंगे. जहाँ तक आपने बात की ना इंक्वायरी की, वो तो हमें समझ आ गई ना. आपने एक आईनी बात कर दी, वो समझ आ गई. अब ये हो सकता है नहीं हो सकता, अभी हमें इस मफरूजों में क्यों जाएंगे. नहीं, लेट्स स्टे आइन पे बात करें, क्योंकि अब आप 184(3) में आ रहे हैं. देखिए इसमें 184 का दरवाजा खुलता है, इसमें पब्लिक इंटरेस्ट का एलिमेंट आ जाता है. हर जज की सिक्योरिटी ऑफ टेन्योर एंड इज रिमूवल आई थिंक इज अ मैटर ऑफ पब्लिक इंपॉर्टेंस, इसलिए उसका दरवाजा खुल जाता है. आ गई बात इन्फोर्समेंट ऑफ फंडामेंटल राइट्स, आपने बात कर दी ड्यू प्रोसेस एंड फेयर ट्रायल, बिल्कुल ये भी समझ आ गई. मगर अब ये जो बाकी चीजें ये इसमें कुछ समझ नहीं आ रही बात.
इसलिए कि जो
हो सकता है सही भी हो तो सो व्हाट.
ये पोर्शन मैंने पढ़ के आपने कहा तो मैंने पोर्शन पढ़ा.
अच्छा इसको छोड़े, कोई और बात करें.
चलिए तो मैं
नहीं, कोई और बात करें तो बताएं.
मेरी तो गुजारिश सिंपल ये है कि दिस इज अ केस वेयर ए जज हैज बीन रिमूव्ड विदाउट फॉलोइंग द ड्यू प्रोसेस.
We got the point. And we are just saying how to go forward. That's all.
This order has to go. This report has to go. Has to be quashed. So that in the future.
But what about the public interest in the matter? They need to know. So, or they are not entitled to know.
उसके लिए मैंने ऑलरेडी सबमिशन की है कि ये ऑर्डर सेटिसाइड होके इसको जनाब रिमांड कर सकते हैं सुप्रीम जुडिशियल काउंसिल एंड इंक्वायरी इनटू द मैटर. दैट इज द आंसर टू माय माइंड. इफ योर लॉर्डशिप थिंक्स
अगर आप नहीं ठीक है, इफ यू कंक्लूडेड, वी डोंट वांट टू कट यू शॉर्ट, कैन वी मूव ऑन टू सलाउद? आई जस्ट सॉ दैट ही इज इन कराची.
जी ठीक है सर, मेरी सबमिशन ये है कि रिमूवल विदाउट इंक्वायरी इज अनकॉन्स्टिट्यूशनल एंड ऑट टू बी स्क्वैश्ड.
हामिद साहब, आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई थी, क्योंकि प्रोसीडिंग्स 2 महीने से ज्यादा चली हैं और कम से कम 2 से 3 रिप्लाईज इन्होंने जमा कराई हैं. मैं आपसे पूछ रहा हूँ, हामिद साहब आपसे पूछ रहा हूँ.
जी सर, सॉरी,
मैं ये कह रहा था कि आप इस एस्पेक्ट को तो डिनाई नहीं करेंगे कि जस्टिस सिद्दीकी साहब को एम्पल अपॉर्चुनिटी ऑफ हियरिंग दी गई है, 2 महीने से ज्यादा प्रोसीडिंग्स चली हैं और इन्होंने कम से कम 3 से 4 रिप्लाईज अपनी जमा कराई हैं. लिहाजा ये एस्पेक्ट कहना कि जी इनको अपॉर्चुनिटी ऑफ हियरिंग मिली ही नहीं या इनको टाइम नहीं दिया गया, तो ये तो किसी हद तक के दुरुस्त मालूम नहीं होता रिकॉर्ड से. देखें अब प्रोसीडिंग शुरू हुई है 23/8 23/7 को और कंक्लूड हुई हैं 1 अक्टूबर को, यानी कि तकरीबन 2 महीने से ज्यादा चली हैं प्रोसीडिंग्स। और सुन तो लीजिए, और कम से कम 2 से 3 दफा इनकी रिप्लाईज आई हैं, और उनकी रिप्लाईज जितनी भी हैं वो सुप्रीम जुडिशल काउंसिल ने कंसीडर करी हैं और सारी रिप्रोड्यूस की हैं अपने ऑर्डर के अंदर, और उसके बाद फिर इनके खिलाफ ये फैसला दिया गया है कि जनाब ये मिसकंडक्ट के मुर्तकिब थे। इसके बारे में आपका क्या कहना?
जी, मैं ये कहता हूं, उन्होंने एक शो कॉज नोटिस दिया 31/7/2018, उसके जवाब में एक प्रिलिमिनरी मैंने सबमिशन की, क्योंकि 14 दिन दिए गए थे। मैंने कहा मैंने फैक्ट सारे डॉक्यूमेंट्स कलेक्ट करने हैं और मैं एडिट रिप्लाई दूंगा। फिर मैंने एडिट रिप्लाई दी, ये 2 रिप्लाईज मैंने दी है। एक एप्लीकेशन मैंने और दी उसमें, जो रिकॉर्ड पर है पेज 223-24 पे, उसमें मैंने कहा कि इन द फर्स्ट प्लेस addressing a district bar association is not a misconduct within the meaning of Article 209, but if this honorable council thinks that this is a case in which I should be proceeded against, please in that case give a public hearing to us, give it as an open court। मैंने ये एप्लीकेशन दी, जिसको कभी उसके बाद एक इन कैमरा प्रोसीडिंग्स हुई, उसमें भी मैंने ये बात रिपीट की कि अगर जनाब मजीद प्रोसीड करना चाहेंगे, उनको तो प्रिलिमिनरी इंक्वायरी थी, वो कोई फाइनल इंक्वायरी जो है सिटिंग नहीं थी, तो मुझे आप ओपन हेयरिंग दीजिएगा। ये पेज 313 के ऊपर ये मौजूद है मेरी दरखास्त,
पेज
313 पर, पेज 313, ये वॉल्यूम 2 होगा जी इसका, इस केस का पेपर बुक 2। इसकी तारीख है 29/9/2018।
पेज क्या बताया था आपने?
The applicant
पेज आप दोबारा
313 सर,
313
application for open hearing guaranteed under the Constitution of the Islamic Republic of Pakistan।
ये इसकी आपकी इस्तदा कौन से पेज पे? इस पे फैसला क्या हुआ?
It is therefore prayed।
इस पे क्या फैसला हुआ
जी?
डिसाइड क्या हुआ? डिसीजन
नहीं, उससे नहीं हुई। I was never given any hearing। इसके बाद the one hearing was in camera।
इसमें इशू तो ये है कि जहाँ तक तकरीर की बात है, आप तकरीर डिनाई नहीं कर रहे हैं, मालूम सिर्फ ये करना है कि ये मिसकॉन्डक्ट में आता है, यानी नंबर 1। इसका दूसरा एस्पेक्ट जो है, जो कि बार बार मैं इंसिस्ट कर रहा हूँ, वो ज्यादा इम्पोर्टेंट है कि वो जो एलिगेशंस थी उसको मालूम करना चाहिए था दुरुस्त थी या नहीं थी। तो क्या सुप्रीम जुडिशल काउंसिल वो तहकीकात कर सकती है? सपोज अगर आज हम रिमांड भी करते हैं, तो क्या वो तहकीकात वहाँ हो सकती है या इसको कहीं और होना है?
हाँ, बिल्कुल इसमें इंक्वायरी होनी चाहिए थी, बल्कि पहला
कौन करेगा इंक्वायरी?
सुप्रीम जुडिशल काउंसिल को करनी थी ना।
नहीं, वो दूसरी एलिगेशन की जो इन्होंने एलिगेशन लगाई, उसके बारे में क्या कहते हैं?
तो एलिगेशन
ये जो कह रहे हैं, जो कोर्ट्स पे जो बाकी रिस्पोंडेंट्स पे जो एलिगेशन लगी है, क्या सुप्रीम जुडिशल काउंसिल उस हद तक तहकीकात कर सकती है?
बिल्कुल कर सकती थी, और बल्कि मैंने ओपन हेयरिंग के लिए कहा था कि आप हमें ओपन हेयरिंग दें।
देखिए, शायद मैं क्लियर नहीं कर रहा हूँ। आप पे ये एलिगेशन तो नहीं है कि आप सही कह रहे हैं या गलत कह रहे हैं। आप पे एलिगेशन ये कि आपने जुडिशरी को मिलाइन किया, जो कि मिसकॉन्डक्ट में आता है।
ठीक,
वो तो आप मान रहे हैं कि तकरीर की सिर्फ ये देखना है कि आपकी तकरीर ज़ुमरे में आती है या नहीं, लेकिन जो एलिगेशन है उसकी तरफ तो किसी ने तवज्जो नहीं दी कि वो एलिगेशन किस हद तक दुरुस्त है, किस हद तक गलत है। उसकी गलत है तो ही शुड फेस द कॉन्सिक्वेंसेस, और अगर दुरुस्त है तो रिस्पॉन्सिबल ही शुड फेस द। लेकिन सवाल ये कि कौन करेगा?
लेकिन उन्होंने इंक्वायरी करनी थी ना इसमें। पहले तो मुझे स्टेटमेंट ऑफ एलिगेशंस देना था कि ये एलिगेशंस हैं इनका, इसको आप मीट करें।
कोई स्टेटमेंट ऑफ एलिगेशन
कुछ नहीं किया गया। सो गुजारिश मेरी ये,
सुप्रीम जुडिशल काउंसिल वेरी पावरफुल बॉडी। आप जरा 210 भी पढ़ लें आइन का।
ये बिल्कुल सही है कि
जरा देखिए इसकी जरा मैंने अभी इसके जरा अल्फाज का चुनाव जरा देखिए.
Power of council to enforce attendance of persons, yes.
नहीं टेक्स्ट पढ़िए ना.
For the purpose of inquiring into any matter,
not pertaining to, it doesn't connect with the conduct of the judge. अब यहाँ widened up the scope. जरा आप पढ़े आगे.
Sir, वो इससे connected.
नहीं जरा चले पढ़ते
The
हैं
council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction or order shall be enforceable as if it had been issued by the Supreme Court. The provisions of Article 204 shall apply to the content powers. So
it's a very powerful body. It can call anybody.
That is what, in the context of inquiry, naturally, it has to be.
It's not hearing a case. It's inquiry. So वो आपने जो इंक्वायरी कमीशन की बात की तो ये खुद ही इंक्वायरी कमीशन है इन अ वे. It's more powerful than inquiry. कंटेम्प्ट के पास भी इनके पास है.
बिल्कुल सही है. मैं इसीलिए कह रहा हूँ मैं submitted. The answer is
खान साहब, let me put my anxiety to you. Every Supreme Judicial Council is not the Supreme Court. It's a separate constitutional body. Agreed? Every constitutional body should have maximum autonomy to decide matters. Agreed? Thirdly, we don't want to encroach or say or do anything. It just so happens that I'm a member of the Supreme Judicial Council as well, but we create precedent as well. That it undermines the Supreme Judicial Council. Supreme Court is not a watchdog over. However, like every other constitutional body, when a constitutional provision or a fundamental right is being violated by anybody or not being considered, let's both ways, then the Supreme Court is the only court which has the power, or the High Court, not in this case, to direct that this be done.
Yes.
So we have to be very careful how we proceed in this matter, because it will, like you are citing Justice Clark's case after 50 years, this will become precedent and it will be cited before us maybe earlier than 50 years. So we have to be very careful as to not disturb the perfect balance that the constitution makers have provided in the constitution.
There is an intervening judgment 2018 की, उसमें ये सारे एस्पेक्ट्स बहुत अच्छे डिस्कस हुए हैं और उसमें ये आया उसकी हैसियत क्या है ये भी डिस्कस हुई है. मेरी गुजारिश है उस जजमेंट को जरा PLD 2018 सुप्रीम कोर्ट 538. I was counsel that case. Again, Shaukat Siddiqui's case.
This is Iftikhar Chaudhry's case.
This is PLD 2018.
वो अच्छा एक और जो आपका मैटर नहीं ये नहीं का है, ये तो आप ही का केस है ना.
जी वही. इसमें ये एस्पेक्ट प्रोसीजर एस्पेक्ट्स बड़े डिटेल में डिस्कस हुए हैं.
Which part you want to read from?
जी अब मैं आपको वो जो है ना बता दें कि वो मेरे नोट्स निकाल लो. नहीं दूसरे वाले नोट्स में
पेज 5559 पे आ जाए.
538 से जनाब
पेज 5559 पे पैराग्राफ 51.
My Lord, my lords, am I needed for these proceedings, or can I be excused for now?
Is there something urgent?
Yes, I have. There's a matter which I have to argue, not before.
Okay, fine. ठीक है.
But
कोई बात हुई उनको बता देंगे. But you've noted the points,
I have.
ठीक.
Sir, this judgment is very thorough judgment discussing various aspects of Article 209. पहला जो point out करूँगा वो page 555 है, para 46. जी. Historically, Page 555,
historically,
46. Historically, the fundamental rights of the people require protection from the excess of the executive and the vested interests, both commercial and political. In order to safeguard the fundamental rights of the people guaranteed under the Constitution, the independence of judiciary obviously must be insulated from the onslaught of the executive and such vested interests who are past masters at institutional capture. Thus, the security of tenure of judges, more so those of the superior courts, is imperative, and therefore adequate safeguards in this behalf are provided, including by enacting what appears to be a rather cumbersome and strict process of their removal. This cardinal principle is reflected in the constitutional dispensation of all the democratic countries, people by citizens and not subjects. The exception in this behalf are almost always found in...
Fine, you don't need to say this, it's obvious, जी.
नहीं सर, एक ये बात जो एक बहुत important aspect है, वो जनाब देखिए पेज 559, ये जरा पैरा 51, ये जरा जरूर देख लीजिए.
पेज
559 पैरा 559 पेज पैरा 51. The relevant provisions of the Constitution, more particularly Articles 209, 210 and 211, when examined in the light of the judgment handed down by a larger bench of this court in the case reported as Chief Justice of Pakistan Muhammad Chaudhary, and the previous pronouncements on the subject noted and quoted with approval in the aforesaid judgment, the relevant portions whereof have been reproduced in extenso herein above, should reveal that, firstly, the SJC is a unique forum created by the Constitution. Secondly, the SJC is not a court, though it may exhibit some of its trappings, including the power to punish for contempt. So it is not a court. Yes, year 2010 की judgment भी है. Thirdly, the proceedings before SJC are essentially a fact-finding inquiry, sir. This is what I am submitting here. This is the function of the SJC. Fourthly, the SJC is akin to a domestic forum, and it conducts administrative proceedings regarding the question of conduct or capacity of a judge who is to be judged by his own peers. Fifthly, the findings of SJC are recommendatory in nature and do not enjoy the status.
So, yes, agreed. What is the point you want to make?
I'm trying to make here it's a domestic forum. Your Lordship was saying that it's just like as if it is some kind of a rival court to Supreme Court. No. It is a domestic body.
No, it is not. It's a constitutional body.
It's a constitutional body.
So, what happened in this case? Why did you come to court? What relief did you get or not get?
इसका primary function जो है वो inquiry है.
नहीं, ये फैसला जो आप साइड कर रहे हैं, ये क्यों आया आपका केस सुप्रीम कोर्ट में?
ओपन इंक्वायरी
केस क्यों आप लाए सुप्रीम कोर्ट ये वाला?
ये इसलिए कि हमने कहा था कि इस केस में कि हमारी ओपन इंक्वायरी होनी चाहिए.
तो सुप्रीम कोर्ट ने क्या फैसला किया?
सुप्रीम जुडिशल काउंसिल ने कहा नहीं, इट शुड बी इन फोरम. इस केस में
फिर तो आप ये ग्रीवेंस दोबारा एजिटेट नहीं कर सकते हैं ना हमारे सामने.
नहीं, बात क्या हुई, इसमें उन्होंने अलाउ कर दी ओपन इंक्वायरी. दिस जजमेंट अलाउड ओपन इंक्वायरी subject to certain conditions.
वो पैराग्राफ किधर है?
जी वो उधर भी आ रही है. It's a very historic judgment in that case में
आप तो कहते नहीं अलाउ हुई
हैं?
सब SJC
कि क्या फायदे?
वो वापस भेजा है ना सुप्रीम जुडिशियल काउंसिल को 577 पैरा 96.
वो एक
Consequently, the question regarding the conduct of proceedings.
नहीं, तो ये तो वो रिमांड हो गया ना. ये केस रिमांड का केस है.
नहीं, इसमें उन्होंने कहा कि
नो आमिद खान साहब
सब्जेक्ट टू सच.
हम जो इतनी देर से आपसे सवाल पूछ रहे हैं, ये पैराग्राफ 96 जो माय लॉर्ड ने पॉइंट आउट किया, सब पढ़िए.
नहीं वो ठीक है, उसे
आप पढ़िए तो.
सर बात ये है,
आप पहले पढ़ें तो ना 577 पे.
Consequently, the question regarding conduct of proceedings through an open justice as requested by needs to be revisited and decided afresh by ACG, not standing uninfluenced by its order dated so and so. जो order set aside उन्होंने किया.
आप पढ़े ना.
In the light of the observations made herein above. In the light of the observations.
So this is
observations क्या हैं?
एक सेकेंड
जी.
सर हमारी बात सुन लेना. अभी हम आपसे बार बार पूछ रहे थे रिमांड, तो ये रिमांड ही तो किया है.
पिछले सवालों का जवाब है
तो ये पहले सवाल का जवाब इधर मिल रहा है.
मैंने भी तो रिमांड ही मांगा है.
नहीं, अगर आपने बताया ही नहीं, आप कोई और वजह से बताया.
जजमेंट का मैं ये कह रहा था कि उसमें
फिर क्या किया सुप्रीम जुडिशियल काउंसिल ने इस ऑर्डर के बाद?
इस ऑर्डर के बाद उन्होंने अलाउ की थी. इन दैट पर्टिकुलर केस दे अलाउड ओपन हियरिंग.
वो ऑर्डर कहाँ है?
वो कोई दूसरा रेफरेंस था?
वो दूसरा रेफरेंस, वो रेफरेंस 242 है.
अच्छा, ये केस नहीं है.
जो इस केस में इम्प्यूग्न था वो रेफरेंस 242.
लेकिन इस रेफरेंस की तो बेसिस जो है वो तकरीर है, और उस तकरीर को आप डिनाई नहीं कर रहे हैं, उसके कंटेंट्स को.
ठीक है, but then that has to be inquired into. तो मेरा गुजारिश ये करनी थी, जो जनाब के ऑब्जर्वेशन.
नहीं, that reference was dismissed. What happened?
That was never decided.
You want that
proceeding stay को.
You want that be also be decided. आप चाहते हैं कि उसको भी डिसाइड करें?
नहीं सर, बिल्कुल
नहीं, इसकी बात नहीं. मैं तो आपके सामने आपका प्रेसिडेंट दिखा रहा हूँ कि प्रेसिडेंट ये है. फिर उसमें इंक्वायरी के तरीकाकार इसमें बड़ा अच्छा तरह डिस्कस हुआ है, वो भी जरा देख लीजिएगा. उसमें उन्होंने कहा कि ये जो इंक्वायरी होगी सुप्रीम जुडिशियल काउंसिल की, उनके ये पैरामीटर्स होंगे. मैं उसकी तरफ जनाब की तवज्जो दिला रहा था. वो तो आखिरी में उन्होंने कहा कि जी ठीक है, रिमांड कर रहे हैं आप, इस जजमेंट की लाइट में आप डिसाइड करें. परफेक्टली ऑल राइट. वो एक पैरा था, मैं कहा था इंक्वायरी में ये कुछ होना चाहिए.
तो खत्म.
जी सर. सो मेरी गुजारिश ये है कि all the judgment so far says that a judge cannot be removed on the basis of a report which is not based on inquiry, and this is the case. Without inquiry, the Supreme Judicial Council has submitted a report in which they have recommended the removal of the judge, and therefore that is clearly an unconstitutional, void, non-est order. About what Lordship was saying, उसके बारे में मेरी गुजारिश ये है कि प्रोसीडिंग्स में शो कॉज नोटिस हुआ एक, उसके 2 दफ़ा, पहला प्रिलिमिनरी रिप्लाई, फिर एडिड रिप्लाई, ये हुआ. उसके बाद एक एप्लीकेशन मैंने दी जिसमें मैंने कहा कि अगर अव्वल तो ये एड्रेसिंग ए बार एसोसिएशन इज नॉट ए मिसकॉन्डक्ट, बट इन केस यू वांट टू होल्ड इंक्वायरी, प्लीज होल्ड इट इन ओपन कोर्ट. वो जजमेंट वो भी मैंने दिखा दिया. उसके बाद उससे 2 दिन बाद जब हियरिंग हुई, उसमें ये सारे सवाल आए और उसमें हमसे ये पूछा गया कि हाँ इंक्वायरी है, हमने बिल्कुल ये तकरीर की है. ठीक है.
नहीं, एक सेकेंड. सो देयर वर 2 रेफरेंसेस. एक में अलाउ हो गई आपका ओपन और दूसरे में नहीं अलाउ हुई.
नहीं, दूसरे में तो
आपने कहा था, आपने दरखास्त दी थी ना ओपन के लिए.
सर वो तो ओपन क्वारी का तो प्रेसिडेंट बन चुका था. ओपन क्वारी का तो प्रेसिडेंट हो चुका था.
अभी आपने कुछ देर पहले कहा कि उसमें इंक्वायरी ओपन नहीं हुई थी, मैंने रिक्वेस्ट की थी.
उसमें नहीं हुई.
तो एक में किया और एक में नहीं किया.
इसमें नहीं किया.
फर्क क्या है दोनों में?
फर्क ये है कि आफ्टर, इसमें तो इंक्वायरी सिरे से नहीं हुई ना. उसमें
नहीं, मैं अब इंक्वायरी की बात नहीं कर रहा हूँ. मैं अब कह रहा हूँ प्रोसीडिंग्स कि वो प्रोसीडिंग्स ओपन करें जी, वो इन कैमरा ना करें. एक में तो आपकी दरखास्त अलाउ हो गई.
जी
आप कह रहे हैं
बिल्कुल,
वो रेफरेंस नंबर 242 में. 242. मगर इस केस में इसका रेफरेंस नंबर क्या था?
मौजूदा रेफरेंस.
हाँ, इसमें आपने कहा नहीं हुई.
इसमें तो इंक्वायरी नहीं हुई सर.
इंक्वायरी इज अ सेपरेट थिंग. ओपन प्रोसीडिंग्स की बात कर रहा हूँ।
ओपन प्रोसीडिंग्स देखो, प्रोसीडिंग्स इंक्वायरी की होनी थी ना, इसमें सिरे से इंक्वायरी नहीं हुई।
नहीं, वो एक अलग पॉइंट है, प्रोसीडिंग्स ओपन हुई या नहीं हुई?
एप्लीकेशन पे कोई ऑर्डर नहीं हुई,
यानी जितनी प्रोसीडिंग्स,
इसका नंबर क्या है रेफरेंस का, ये वाली मौजूदा का
347, जितनी
ठीक है, समझ गया
ओपन नहीं हुई।
So distinguish.
Got it. ठीक है, खत्म। Can we ask Mr. Salahuddin? We want to wrap it up. Mr. Salahuddin, you've been hearing everything?
I was not able to be to Islamabad because of lack of availability of
what is the way forward? Address that point only.
My Lord, my submission is that the report and the notification is to be set aside on the ground of being malafide in law.
Please tell us the way forward.
Yes, sir. My submission is that it cannot be remanded to the SJC. The SJC scope is limited under Article 209. However, this court, if it considers fit, and I would urge that it
who do you represent? Who do you
the factual merit.
Ek second hai, na. Who do you represent?
My Lord, the Bar Association, Karachi Bar Association, and the
So you basically you don't want the truth to come out.
No, sir.
Yes.
In fact, my petition is.
You are saying. Please hear us. You are saying that the relief should be given to the petitioner, but the people of Pakistan should be kept in the dark because they can't handle the truth. So why can't it be remanded? Why are you saying it can't be remanded?
No, not at all, sir. I'm not saying that it should not be investigated. My submission is that the proper forum would either be this court itself or a commission appointed.
We are not seeking your opinion. We are seeking some legal response. In my opinion, that doesn't help us, does it? Why can't it be remanded?
It is because of the language of 209 itself, sir.
Where does it suggest that? In fact, Mr. Hamid Khan has just cited a case where it was remanded, the matter was remanded.
इसमें ये जो केस इन्होंने रेफर किया है इसको डिस्कस करा है
not arguing.
15
It cannot be remanded. If Mr. Shaukat Siddiqui was still now,
we can't. Voice is gone.
48.
So the council to recommend his removal. Therefore, it does not have then the jurisdiction under 2096. And so the remand right now cannot be done. It could have been done 2 years ago. But right now, the remedy is that uncertainty those allegations.
So you mean to say, you mean to say, on account there is a well-settled principle that no one should suffer as a consequence of act of court. So you're saying because the court delayed the matter for 2 years, the petitioner's valuable right has been taken away from him. Is that your argument?
And
we can't hear you. You're not speaking clearly. करें ना ठीक इसको.
That the civil servants' actual tenure has ended.
Civil servant को आपने judge बना दिया.
नहीं सर, मगर
अब आप please don't.
Disciplinary proceedings का principle तो वही है सर.
No, it's not. Please, no, don't do this. If you're reducing a constitutional office to the level of a bureaucratic thing and saying the same principle applies, with respect, I will not agree with you.
My submission is that the stigma around a person's reputation caused by wrongful removal, that is something that he is entitled to remove, even if he has finished his age of service. It is the same principle which your lordships entertain appeals against convictions, even when
Mr. Salahuddin, please, Mr. Salahuddin, please focus on the Constitution Mr. Ahmed Khan has read 2095, which says inquiry, then 2096, which talks about inquiry, and you are saying there's no need for an inquiry because he's retired, he's attained age of 62, so even if SJC did not comply with the constitution, so let him suffer.
Yes, sir. What I am saying this court is to set aside the report of the Supreme Judicial Council and the President's notification on account of being without jurisdiction and then
we are asking you, can it be remanded or not? We're not asking you, can it be set aside?
My submission is the reason the factual allegations cannot be investigated anymore by the Supreme Judicial Council is because
are you saying that we should take over the functions of the Supreme Judicial Council? That's the only solution then. There's no other way. Either they do it or we do it.
The Supreme Judicial Council has a specific role.
Mr. Salahuddin, you're not providing us any solution. You are saying the Supreme Court should assume the functions of the Supreme Judicial Council.
Yes, sir. The Supreme Judicial Council will end if a judge, for whatever reason, is no longer there.
Then why are you saying for whatever reason we are dealing with a real case?
Yes, sir. He has crossed the age of superannuation.
So he should suffer. He should suffer because of that.
No, I'm not saying he should suffer.
I don't know.
I'm saying the order can be set aside.
Without conducting inquiry, we should set aside the order. Why?
The order should be set aside
without inquiry. No, without inquiry.
Irrespective of the merits of the case, the order is without jurisdiction, therefore it deserves to be set aside. It is without jurisdiction for two reasons. The first reason is that the inquiry was not initiated.
If you are arguing in this manner, what provision of law have you filed your petition under?
184.3.
What's the first word in that? Then you don't have a case. Then we should dismiss your petition on that ground alone, because you're arguing against your own petition now. You are saying you're now claiming the right of an individual and not the public's right. Please read 184.3. It starts with the word public importance. So you are now pleading the case of the petitioner, not the public's. You're not saying exactly what you're doing. You say public should not know the truth of the matter. Please give him his pension and that's it.
So the aspects of public importance.
184.3 पढ़िए ना जी.
So the first aspect of public importance is that whether the SJC has the legal right to remove judges without a factual inquiry. That is a question of public importance. The second question of public importance here, which is separate, is whether the allegations of Mr. Shaukat Siddiqui were correct or not. That has to be investigated separately. My only submission is that the SJC no longer can do so. The reason I am saying this is,
you don't. When you say a statement, back it up. That has to be investigated separately. I'm quoting your words. How? That's the only question we are asking you.
Your Lordships, in 184.3, your Lordships can.
I'm just quoting you. I'm quoting your words. Who will investigate? We. Say, tell us.
The truth of the allegations can be determined by this court.
So we record evidence. We will record evidence. We will record evidence.
There's no bar to it, sir. But if your Lordships feel that
feel की बात तो नहीं हो रही है. You are assisting the court. We don't go on feelings. Assist the court on the constitutional point, not on our feelings.
My lord, there is no bar under 184.3 to recording of evidence. It is done even in constitutional petitions under Article 199.
ये तो आप हमें वे फॉरवर्ड हम बार बार पूछ रहे हैं ना, वे फॉरवर्ड बताएं.
गुजारिश ये है कि it may be referred to a commission.
Sir, if you can speak slowly, we can't hear your words.
Mike se thoda piche ho jaye. Mike se thoda piche ho jaye.
Ji, sir. My submission is that it may be referred to a commission that inquires into the factual truth or otherwise of his allegations. Because I completely agree that the allegations are of such a nature that the public has a right to know whether they are true or not.
Where does the Supreme Court have this power to appoint a commission?
My Lord, the power is 184(3). And
no, don't just say these things. No. Read the language. Where does it say Supreme Court can appoint a commission?
Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article. Now,
now please stop. Go to 199 and say as that the High Court can constitute a commission. If they can, we can.
My Lord,
unless you want us to start writing into words into the Constitution, you can't just say, just throw in something and say commission should be instituted. Commission, the only commission that I'm aware of is Commission of whatever Inquiry Act of 2017,
yes, sir.
Which the federal government constitutes. So where is the power of the Supreme Court to constitute a commission?
My Lord, the mandamus would issue to the federal government.
अब आप कहीं और जा रहे हैं तो आपकी प्रेयर में तो ये बातें हैं ही नहीं ना.
What do you say about 210? Article 210. जरा पढ़ें.
For the purpose of inquiring into any matter, the Council shall have the same power as the Supreme Court has to issue directions or orders for securing the attendance of any person or the discovery or production of any document, and any such direction shall be enforceable as if it had been issued by the Supreme Court.
What do you say about when in presence of such a vast powers, why you are reluctant to remand the matter to Supreme Judicial Council?
सर मेरा ये कहना है कि साथ में 209(5) और 209(6) भी देख लिया जाए.
पढ़े?
If on information from any source, the Council or the President is of the opinion that a judge of the Supreme Court or a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity, may have been guilty of misconduct, the President shall direct the Council to, or the Council may, on its own motion, inquire into the matter.
That's a very point we've been saying. Inquire. Admittedly, SJC did not do that. And I'm not following you at all. You're not citing any precedent, or you are just saying, in my opinion, feelings. I mean, let's go on the Constitution. What does it say?
My Lord, the Constitution says that the SJC can inquire into the conduct.
That's the whole point. They did not inquire. That's a case. Hamid Khan's case is.
Yes, if I may explain, sir.
It's not an explanation. It's a fact. Either they did or they didn't. They did not inquire.
This is admitted fact.
Sir, if the SJC report and the President notification is set aside, does Mr. Shaukat Siddiqui automatically become a judge of the High Court? No, he does not. And because he does not become a High Court judge, then the SJC cannot inquire.
At least he will get the status of ex-judge of the High Court. Former judge. He will get the status of ex-judge of the High Court.
Exactly, and there is nothing in 2095 that allows the SJC to inquire into the conduct of an ex-judge. Then if your lordship sees 296 has to be
at that time, there's a settled principle of law. When a list comes before a court, it has to be decided at what was there at that time. Not aaj law ye ho gaya. Suppose a crime is created today we will not decide it as today. We will decide it when the law was at that particular time. It's well settled principle, unless specific retrospectivity is given to something. So merely saying these things, we can simply avoid what you are saying, that the list before the SJC, we are considering matters, we're going back, traveling back in time. Whether time is moved forward or not, whether he's attained the age of 65, 62, are all subsequent events, coincidental events, which one view is they are very material, that the minute the watch goes forward, 62 is struck out of court. I gave an example, you were not listening maybe, that before he could file a petition, the next day he retired. So he has no remedy, then you can say, yes, he has no remedy. Let's at least be on the same line. I mean, then I can appreciate it if you use the same logic. But you're simply saying because he's retired, that's it. So then he's condemned. You can drag on proceedings, you can curtail a proceeding.
That is the opposite of what I am saying. I am saying that if a person retires...
But we are not talking about if a person, we're talking about a judge. This is not a bureaucrat here before us. Let's use the word judge.
Right. If a judge retires, and your lordship comes to the conclusion that the SJC order was without jurisdiction.
We are not saying that. No, we are not saying that at all. You've not been following. We are simply focusing on one point and one point alone. No inquiry was held. Without jurisdiction, we are certainly not saying, yes, Supreme Court had jurisdiction.
My humble submission is that factual, the lack of a factual inquiry renders those proceedings forum non juris and without jurisdiction. If there are factual aspects that have to be looked at into, and the domestic forum or the SJC doesn't look into it, then that renders the decision of that forum without jurisdiction and malafide in law.
This you are arguing on the basis of a normal petitioner. Then why should we entertain your 184(3) petition? Where is the element of public interest? We will concern ourselves with the petitioner, the judge before us. You have got no concern with the matter then. If this is your argument, if you merely want him, whatever, that the order set aside, how does it benefit or not? Or how does it, for independence of judiciary, transparency, right of information of the public, then you've removed the entire public importance aspect of the case from your case. Then we should not hear you, we should dismiss your petition, we should just hear Mr. Hamid Khan. If you're taking away you're removing all the public element from it. If the public element is removed, then how are you invoking the 184(3) jurisdiction? The same question, Mr. Khan has also come before us in 184(3). On the thing, it's not just me, it's independent of the judiciary. I mean, has the independence of the judiciary been restored because now he'll be entitled to pensionary rights? Is the truth not important anymore?
My lord, it is certainly important, as I have said, but forum is different. But what I am saying is the public importance is there, because if the Supreme Judicial Council removes a judge of a superior court without holding a factual inquiry, then your lordship has to declare that
you are repeating yourself. I don't think you're going forward.
Salahuddin Sahab, Supreme Judicial Council Procedure of Inquiry 2005, इसका Section 8 Subsection 7.
जी सर,
वो जरा पढ़ें आप. Without prejudice to the foregoing, the Council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by Council to be just and proper in the circumstances. और उसके बाद मैं आपसे कहूंगा जरा पेज नंबर 48 पे इम्प्यून्ड ऑर्डर जो है इसका पैराग्राफ नंबर 15 पढ़ लीजिए जरा आप. पेज नंबर, ये हामिद खान साहब की जो पेपर बुक है इसका पेज नंबर 48 और पैराग्राफ नंबर 15।
जी सर,
ये पढ़िए जरा। आफ्टर हियरिंग द लर्नड अटॉर्नी जनरल,
जी, आफ्टर हियरिंग द लर्नड अटॉर्नी जनरल फॉर पाकिस्तान and Justice Siddiqui at his learned counsel at great length, the matter was adjourned by the council to 8/10/2018 for deliberating upon the respective submissions and to determine the way forward, keeping in view the peculiar circumstances of the matter at hand. The council met again on 8/10/2018 and the entire matter was deliberated upon from diverse angles. It was pertinently observed by the council that Article 2095 of the Constitution of the Islamic Republic of Pakistan authorizes the Supreme Judicial Council to inquire into conduct of a judge of the Supreme Court of Pakistan or of a High Court upon a direction of the President of Pakistan or on basis of an information received from any source or on its own motion, and Supreme Judicial Council Procedure of Inquiry 2005 prescribes the mode of conducting such an inquiry. I think, if your Lordship, if I may skip a few and go to the about 10th last line of the next page.
जी, आप 10th last line 4th line से पढ़े। It was इनका जजमेंट का रेफरेंस दिया गया है। जो हामिद खान साहब ने जो रेफर किया है, इसके जजमेंट का रेफरेंस दिया है इसमें। ये पढ़े आप, इसी कंटिन्यू करें इसको आप।
जी सर, जी।
In the case of Justice Shaukat Aziz Siddiqui and
in the case of Justice Shaukat Aziz Siddiqui, the Supreme Judicial Council procedure of inquiry was held by the Supreme Court of Pakistan.
KPLD 2018 Supreme Court 538 इसका रेफरेंस है। जी, कंटिन्यू करें।
जी, to be constitutionally valid and compliant with university accepted principles of due process. In the present matter, initial scrutiny of information was conducted in terms of para 7 of the said procedure of inquiry.
ये जो मैंने पढ़ा था।
A discussion and inquiry into the information was undertaken in terms of para 8 of the procedure of inquiry. A decision was taken to proceed against Justice Siddiqui and a show cause notice was issued to him along with the supporting material calling upon him to explain his conduct. And after receipt of his 2 replies, the council had met and they decided to proceed further with the matter in terms of para 9 of the procedure of inquiry. And thereafter, the Attorney General for Pakistan was required to conduct the proceedings in terms of para 10 of the procedure of inquiry. After that stage of the proceedings, the said procedure of inquiry remains silent regarding the procedure to be adopted or followed in a given inquiry, and the council is extended the necessary discretion to adopt any procedure which may be found by it to suit the requirements of the inquiry. Such discretion of the council is manifestly explicit from the contents of para 8(7) of the procedure of inquiry, according to which, without prejudice to the foregoing, the council shall have inherent powers to adopt any procedure specific to the inquiry which is considered by the council to be just and proper in the circumstances. As the proceeding against Justice Siddiqui were based squarely upon the making of the above mentioned speech by him and the multiple and pervasive allegations leveled by him.
इसमें वो बताना चाह रहे हैं सलाउद्दीन साहब, इसमें बताना चाह रहे हैं कि हमने इंक्वायरी कर ली है। इनका कहने का ये मकसद है कि इंक्वायरी हो चुकी है, हमने अपना प्रोसीजर अडॉप्ट कर लिया। आपसे एक सवाल, आपकी बात अगर तस्लीम की जाए कि इनके हद तक सेटिस्फाइड कर दें, इनका स्टेटस बहाल हो जाएगा, और दूसरे पोर्शन में जो इंक्वायरी आप कहते हैं वो अलग से कंडक्ट हो। सपोज हम आपकी बात मान लें, इंक्वायरी कंडक्ट होती है, उस इंक्वायरी में ये हम ही करते हैं और ये साबित होता है कि इनकी एलिगेशन गलत थी, फिर क्या होगा? इनका स्टेटस वापस लिया जाएगा? कौन लेगा?
सर, इसमें फिर ये होगा कि there would be it would be go then before the relevant criminal court perhaps, because there would be a question of perjury, there would be a question of
the ex-judge of the High Court will face the criminal charge without the intervention of the Supreme Judicial Council.
My lord, judges are not above the law.
No, the Supreme Judicial Council, they have to face the consequences through Supreme Judicial Council.
My lord, with respect, if someone commits the act of criminal defamation,
no, we don't want these analogies which are not applicable to Supreme Judicial Council or to judges. Let's stay focused on the Supreme Judicial Council, on judges and the Constitution. We don't need any analogies. If you can throw any further light, please continue.
No. My lord, I'm not making an analogy with respect, because
let it go. If you want to contribute, we don't want these analogies.
My lord, this is what is the statement. If the statements are false, then it's not a matter of analogy, then there are consequences for false statements on both sides.
I don't, if I was to deconstruct what you're saying, first of all, it's a never-ending thing ever. Let's take logically what you're saying, as what my Lord had put to you, that if the petitioner's this order is set aside on the basis that no inquiry was held, and subsequently a commission, okay, it's magically formed, we go along with that, and the commission, where is the commission? It's not a court of law, it's not a constitutional body, it's a sub-statute body, naturally, or a body created by an order of a court. It can either be one or the other, not a third one. That finding will prevail over the Supreme Judicial Council, will prevail over the Supreme Court, and on the basis of this inquiry is held, either pursuant to order of the court or the Supreme Judicial Council, a judge can go to jail for perjury. This is the sum total of the argument. I don't follow this.
Let me explain myself, sir. It will not, obviously, the commission, the report of the commission too, does not automatically affect.
First tell us who creates this commission. You know,
it is formed under the Commissions of Inquiry Act, and if your lordship sees in the act,
if a commission of inquiry determines something that this judge had not stated the truth earlier, he will be persecuted for perjury.
My lord, it prepares a report. That report is then forwarded to the relevant body.
आप ये बार-बार ये चीजें कह रहे हैं ना, vagueness, relevant body. We are a highest court. We want to know what is this body. Each word you must.
The criminal investigation agency, sir.
So we are then handing over the fate of judges to some SHO or sub-inspector in police.
If a judge makes a false allegation, he defames someone, commits libel, and it is found to be false, then he should not expect to.
Saudi are not quite getting traction with me, at least.
209 के अलावा
कोई और बात करें, या if you want to file, refer to. You are not, sorry, but you're not referring to any precedent, any law, I mean, these are just opinions stated at the bar. कुछ और हमें बताए ना, कुछ चीज तो बताए ना, कुछ आगे बढ़ने वाली बात.
अगर आप इजाजत दें तो मैं थोड़ा सा ये जो पैसेज
आप ऐसा करें, आप अपना राइटिंग में सबमिशंस कर दें, बिकॉज हमें समझ नहीं आ रही बात, एंड we are maybe you have got better ideas, you can put them in writing and we'll consider them.
May I just summarize the...
No, please do so in writing, because you will carefully think out everything, and I'm sure it will be, because if it's also 10 minutes to 2, आप हमें writing में दे दें, we will certainly consider it. Huh?
जरा आर्टिकल 2095 मैं पढ़ना चाहता हूँ. ये कह रहा है कि if on information from any source the council or the president is of the opinion that a judge of the Supreme Court or of a High Court may be incapable of properly performing the duties of his office by reason of physical or mental incapacity or may have been guilty of misconduct, यानी कि 2095 का ए या बी दोनों में से कोई एक भी अगर अप्लाई करेगा तो 209 अप्लाई कर जाएगा. यानी कि लफ्ज इन्होंने और इस्तेमाल किया है लॉ मेकर्स ने. बात हुई इंक्वायरी के हवाले से तो बड़ी बात हुई और हमने नोट भी करी, लेकिन मिसकंडक्ट के हवाले से कोई एक बात भी कोर्ट में नहीं की गई. टॉकिंग फॉर माई सेल्फ, ठीक है. तो मिसकंडक्ट के हवाले से अगर देखा जाए तो ये जज साहब जो थे जिन्होंने के जो बातें तकरीर में करी हैं, डोंट यू थिंक दैट दिस फॉल्स अंडर द एम्बिट ऑफ मिसकंडक्ट एज पर आर्टिकल 2 जो कि कहता है कि केयरफुल टू प्रेजेंट डिग्निटी ऑफ द कोर्ट, और आर्टिकल 9 जो कि ये कहता है कि ही शुड वर्क फॉर द इंटेग्रिटी ऑफ द इंस्टीट्यूशन ऑफ जस्टिस. नाउ व्हाट आर द इंस्टीट्यूशन ऑफ जस्टिस? Institution of justice are high courts and the Supreme Courts. तो इन दो आर्टिकल्स के हिसाब से आपका क्या ख्याल है कि ये जो पिटिशनर साहब हैं ये मिसकंडक्ट के जुमरे में नहीं आते हैं? अगर थोड़ी देर के लिए हम मान भी लें कि इंक्वायरी वाला एस्पेक्ट जो है वो रह गया था सुप्रीम जुडिशियल काउंसिल से, लेकिन ये जो एस्पेक्ट मिसकंडक्ट का है वो स्क्वायरली अप्लाई नहीं करता है क्या पिटिशनर के केस के अंदर, स्पेशली इफ व्यूड अंडर आर्टिकल 2 एंड आर्टिकल 9 ऑफ दीज रूल्स? तो इस एस्पेक्ट के ऊपर हमें कोई असिस्टेंस नहीं मिली है माजरत के साथ। इंक्वायरी के हवाले से तो जरूर हमें मिली है कि ये इंक्वायरी नहीं हुई और इन लोगों को बुलाया नहीं गया, लेकिन वी हैव नॉट बीन प्रॉपर्ली असिस्टेड, टॉकिंग फॉर माई सेल्फ, विद रिगार्ड टू द एस्पेक्ट ऑफ मिसकंडक्ट जो कि आर्टिकल 209 के बी के अंदर फॉल करता है और जो कि साफ साफ कहता है कि अगर मिसकंडक्ट होगा तो आर्टिकल 209 लगेगा। इसके बारे में आपका क्या कहना है सलाउद्दीन साहब?
मैं जरा ऐड कर दूं माय लॉर्ड की बातों में। क्या जो तकरीर की थी वो मिसकंडक्ट में आती थी?
यस।
उसके लिए इंक्वायरी जरूरी थी?
यस
सर, मेरी दो सबमिशंस होंगी इसमें। फर्स्ट ऑफ ऑल, if what he said in his speech was factually incorrect, then it was misconduct. If it was not factually incorrect, if he had correctly stated the facts, then it was not misconduct, number one. Number two, sir, the other reason why it was necessary to assess whether the allegations were true or untrue was because it would affect the proportionality issue. If, for example, all these allegations were correct and the only grievance was कि ये आपने public speech में नहीं बातें करनी थी, तो then perhaps the SJC, the proper course for the SJC would not to be to remove the judge altogether. The punishment also has to meet the crime and doctrine of proportionality. जनाब ने अपनी कई judgments में
नहीं इसराउद्दीन साहब, I understood your first point. As far as your second point is concerned, there is no other option. ये तो नहीं है कि इस साल इंक्रीमेंट नहीं मिलेगी या दो withholding pays हो जाएंगी. Either you remove a judge or you don't remove a judge. Full stop. There is no proportionality involved in 209 at all. I don't know where you're getting this proportionality element and introducing it into the SJC. Rap on the knuckles, be a good boy, don't do it again. You know, that they can't do. Either they dismiss the complaint or they sustain the complaint and give a finding of misconduct and recommend his removal. That's all. Where's proportionality? Where are you getting this from in 209?
My lord, the court can certainly not give a lesser punishment. Your lordship is absolutely right. It's not a court,
it's Supreme Judicial Council we're talking about.
Yes, sorry, the Supreme Judicial Council, sir. The SJC cannot give a lesser punishment, and your lordship is absolutely right. The question is whether the misconduct complained of is serious enough to justify removal. Your lordship will appreciate that the code of conduct says, for example, that a judge should not be rough in his conduct. Complaints are made against judges that they are rough in their conduct. On those complaints, the SJC would not be justified in actually removing a judge for misconduct because such a penalty would be disproportionate to the complaint made. Because if your lordship sees the code of conduct,
you then agree. You agree with us, ना? Okay, we got it.
जी सर. अब सर एक और जो effect है, and
that offer of filing something you're not availing, you want to conclude, it's up to you.
Sir, there's just one point that I would ask that your lordship hear me on. It'll take 2 minutes, sir. It'll take 2 minutes. If your lordship just sees the order, the report of the SJC, I page 8.
Page 39.
Ji, sir. Your lordship sees that the first note is set up is sent by the secretary of the SJC.
Have you seen that already, Ji?
He is the complainant. Number 2 में अगर आप देखें सर, the chairman of the council passes an order that the Chief Justice of the Islamabad High Court may comment upon veracity of allegations.
जी, Mr. Khan has already referred to it. जी
sir. इसमें सर, the chairman of the SJC has directly started the inquiry
without assigning the matter without assigning matter to other judge.
ये अगर आप प्रोसीजर भी देखें, रूल्स 4 to 9 and of course 209 का 5 and 6, article 209 का 5 and 6, the SJC chairman has no role to play in terms of starting the inquiry. The inquiry has to be started by the Supreme Judicial Council. What is calling for a report from the Chief Justice of the Islamabad High Court and for evidence from Mr. Shaukat Siddiqui, that itself was the inquiry. That is an act fully without jurisdiction, and the entire superstructure based on that falls, sir.
Anything else?
My lord, I'll file my written note, sir.
Okay. Anybody else wants to say anything? We'll wrap it up.
एक चीज मैं जनाब की तवज्जो दिलाना चाहूँगा, particularly his lordship's answer, very specific in this judgment of 2018. Page 569, what are the minimum standards of due process under Article 209? वो चंद लाइनें मैंने पढ़ के सुनानी है आपकी.
Where from? ये
PLD 2018 Supreme Court 538.
अच्छा आप ही का केस जी.
538.
रेलेवेंट बताएं, पेज बताएं. Relevant page.
Relevant at what page do you want to read from?
569.
569.
आपके सामने 569
जी.
अब 69 आपके सामने है जी. सेकंड लाइन से पढ़ना चाहता हूँ. There is no serious dispute.
Mike,
there is no serious dispute between the council appearing before us in this behalf, as none of them did or could have confessed that the procedure to be adopted by SJC can be unfair or unjust. This is obviously essential in order to ensure security of tenure of the judge, which is, as already stated above, is the primary purpose of Article 209 of the Constitution. The controversy perhaps pertains to the standards of due process which need to be observed and whether the SJC procedure of inquiry 2005, more particularly paragraph 13 thereof, meets such standards. There also appears to be consensus amongst the learned counsel, learned Attorney General for Pakistan and learned amicus curiae that except for the disputed paragraph 13 of the SJC procedure of inquiry 2005 and the remaining procedures compliant with the universally accepted principles of due process, including as reflected in our Constitution and the various pronouncements of this court. Now this is very important. The judge whose conduct or capacity is the subject matter of proceedings under Article 209 of the Constitution is issued a notice informing of the allegation against him. He is afforded a right of hearing. The findings are based on evidence. So this is most important. Based on evidence which are recorded in his presence. He is also afforded the right to cross-examine the witnesses and produce evidence in his defense. He has right to be represented by a counsel of his own choice. These are the basic elements of due process given by this honorable court that SJC has to follow. So there cannot be any finding given by without evidence, and that evidence should be recorded in his presence with an opportunity to cross-examine. None of that has been done in this case. So therefore, mere show cause notice means is neither.
Mr. Hamid Khan, Article 10A has been incorporated into the Constitution, but the principles enunciated in Article 10A have been applied even prior to the incorporation of Article 10A. But now Article 10A is very much part of the Constitution. It has raised it to the level of a fundamental right.
Right.
Due process and fair trial.
That's right.
Now, I'm speaking for myself. The point, I mean, even if you have to remove a naib qasid, there is a whole procedure. I mean, that is an employee of the government, not a constitutional office holder. And if surely the requirement should be higher, not lower, than for removing a naib qasid. I mean, I would imagine it should be. And if it, then otherwise, what's the worth of a constitutional office if it's not protected at all? So we have to see the Constitution as a whole. We cannot disregard fundamental rights. We cannot disregard the fact of the absence of an inquiry. If in the absence of an inquiry someone is exonerated is one thing, but if in the absence of an inquiry a person cannot be punished. I mean, I think these are the things which are quite clear and obvious. Now, the problem which is at least agitating my mind, and I want you to submit if you all can do so, is where does the Supreme Court draw its line as the Supreme Court of Pakistan not to encroach upon the domain of the Supreme Judicial Council. The Supreme Judicial Council may do some sort of inquiry. That's not the case before us, whether it was sufficient or insufficient. Here there is no inquiry.
No inquiry.
Unless the speech is in itself so offensive that it merits immediate removal. That's one aspect. The other is, if we read the Shaukat notice, is very much premised on institutions' integrity and institutions being maligned. So everything flows from it. You cannot disregard the content of the speech. Now, the content of the speech there can be two things. It could have been misunderstood. That's not the case here. The question is it what the judge is saying correct, or what the judge is saying not correct? You are saying it's correct, they are saying it's not correct. We wanted to hear their point of view. Yes, I did say this, I did meet him, but for a different purpose, whatever. That's not the case. No meeting, I never spoke to you, I never said anything. Now, we can't throw a coin in the air and decide who's right. Nor can we, which brings for you opened the door of 184.3. It's not a civil petition for leave to appear or a civil appeal, where our jurisdiction is wide and we can do whatever we want to. Now, my understanding of 184.3 is you have two hurdles you have to overcome. Matter of public importance. If you start asserting individual rights, which Mr. Salahuddin I was trying to explain to the point that he's removing himself from the domain of 184.3, otherwise it may be a very good case. So if you come before us under 184.3, then it has to be a matter of public importance. And your rights, you have to link with the fact that removal, if it becomes so easy to remove a judge, then independence of judiciary as a whole is under threat.
Yes.
That's I accept. But if you only say, my removal is wrong, maybe you won't meet the test of 184.3. The next part is for seeking the enforcement of a fundamental right. Now, which is the fundamental right? Article 10A, maybe some other article as well, 25, I don't know, whatever you say. But so that's the thing. Where does the public, once we bring in public interest, public also has a right to know the truth. I mean, it shouldn't be perceived that we protect our own when they don't deserve protection. That's very important. Because this is really in the public domain. So, okay, fine, so the public will say, but did he say it or not? Was it true or not? That's the question I was asking Mr. Salahuddin, and he was not coming up with that because he's actually taking his petition out of the domain of Article 184.3. Maybe it's all very new because these questions have just arisen during the course of the hearing. So we've given him time, and we'll also, and the last point is, where do we go from here? One is remand. Can we do it or not? He's saying once you retire, it's over. The learned Attorney General has referred to some other case and says, till that case is not decided, you should not decide this, or words to this effect. So if you can submit a note on these legal points, we'll reserve it. After, if we require to reconvene again, we will reconvene again. But otherwise, consider this, if my colleagues agree, for reserving the judgment subject to, we may want to reconvene after the notes come, or we may have more questions. I don't know. So is this clear? I mean, Khwaja Sahab, you agree with this course of action, or you can also submit us a note, because not necessarily, you said you're not invested in the outcome, you're more interested as counsel. Now we're calling upon you, senior counsel. You can assist this court. The same applies to Mr. Wasim Sajjad Sahab. He's also very senior counsel. So he also said, I need time to absorb the matter.
With your Lordship permission, I'll submit a written note on legal issues. That
you may. Yes, please leave the facts aside.
Yes, that is
completely out.
We're not going into
at all. Don't mention anyone. No. Just on these issues. If you can, if you want to, you may. We're not directing you to, because you're not a party. Yes, but we felt that things were said behind your back, so you had the right of audience, which we've given you. So, which Hamid Khan Sahab also agreed. आपने पोस्ट तो नहीं किया था ना इनका नोटिस? इनको इशू करना हमने नोटिस आपने पोस्ट तो नहीं की थी ना? ठीक. तो कितना वक्त आप लोगों को चाहिए होगा to come up with some sort, because this is actually not only this case, every case creates precedent, but in these matters, the precedents are very rare. I mean, like very few come, and this point is a novel point, and you said this, it's never happened that no inquiry has been conducted. Now we want to just see whether, I'm not doubting your statement, but Mr. Salahuddin and Mr. Khaja Haris Sahab may tell us no, there are other cases where also inquiry were not held. We would want to know what is the world practice, whether it can be done without an inquiry of the nature that you're setting. We want to know about freedom of expression, of what judges can and cannot say, because one is, I mean, even Khwaja Sahab was not very confident on which particular misconduct it is. I mean, publicity, I mean, so that allegation was not leveled. First allegation should have been leveled, you were seeking publicity. So anything else you want to say, please do so. Otherwise, this will be, we'll consider it reserved. ठीक है, लिख लें आज कोई है लिखने वाला ऑर्डर? आप इसमें लिखें.
2 weeks time. Sir, I need only 1 week to have a comprehensive note on that.
देखिए आप आजकल जरा बहुत सारे केसेस आ रहे हैं, and all of them require a lot of thinking and detailing. So we'll certainly give you more than a week. I mean, it's not that. इसमें लिखिए. We've heard the notices were issued to General Lieutenant General retired Faiz Hamid and Brigadier retired Irfan Rame, and
he's not retired, my lord. We corrected that. He's still in service.
Okay, and Brigadier Irfan Rame. And is he still a brigadier or is he?
He's still a brigadier.
And Khwaja and senior counsel Khaja Haris has entered appearance on their behalf and states that he's filed CMA numbers 267 and 268 of 2024 attending to the allegations leveled against them by the petitioner. So full stop. Learned Senior Counsel Mr. Wasim Sajjad states that he represents Justice Muhammad Anwar Kasi, former Chief Justice of the Islamabad High Court, and has filed CMA number 253 of 2024, attending to the allegations pertaining to him.
3 COS filed.
Huh? एक से काम नहीं बना वसीम सजाद साहब चलें वो लिख लीजिए full stop. Notice was also issued to the former registrar of the Supreme Court of Pakistan, Mr. Arbab Muhammad Arif, who has filed CMA number 270 of 2024. ठीक है, full stop. Next paragraph लिखिए. We've heard Mr. Learned Senior Counsel Hamid Khan for the petitioner and Mr. Salahuddin Ahmed for petitioner in CP number. आपकी कौन सी है Salahuddin साहब? हाँ? 15 of आपकी CP का नंबर क्या है?
I'm sorry, my lord.
What's your CP number?
15 of 2020, constitutional petition.
15 of 2020.
20.
एक और भी है apparently. And two CP's number 2 and 15 of 2020.
221 की है.
अच्छा 221 की अलग नंबर चेक कीजिएगा प्लीज, ठीक है. Full stop. We've also heard Mr. Learned Senior Counsel Messrs. Wasim Sajjad and Khwaja Haris, और कोई तो नहीं, यही सब हो गए. Full stop. And the Learned Attorney General for Pakistan. Full stop. Assisted by मलिक जावेद असिस्ट किया था या उन्होंने आपको असिस्ट किया? अच्छा, मलिक जावेद. फुल स्टॉप. इन नंबर ऑफ फुल स्टॉप असिस्टेंस इसमें लिखिए लीगल लर्नड काउंसिल में सबमिट देयर concise statements. Precise. My lord adds precise and concise. Statements with regard, amongst others, to the following queries which arose during the hearing. Colon. फिर आप इसको 1, 2, 3, 4 कर लें. Whether an inquiry was conducted by the Supreme Judicial Council, and if not, was it a constitutional or legal requirement, and if it was, the consequences of the failure to do so. Question mark. Whether, if the consequence of doing so. Number 2 लिखें. The consequence इसमें लिखते हैं whether that since in the interregnum, that since during the pendency of CP number 76/2018, CP number so and so लिखते हैं was filed on, कौन सी तारीख को फाइल हुई थी? 76
October 2018.
वो डेट ले लीजिएगा. 18 October 2018, and the petitioner attained the age of 62 years
30th of June 2021.
On 30 June 2021, whether what, if any, how can the matter now be attended to if the petition is to be allowed, okay, if he is to be granted, allowed, if he is to be granted relief, including whether the matter can be remanded to the Supreme Judicial Council. Anything else? Whether there was no need to conduct an inquiry by these SJC, as the speech admittedly given by the petitioner in itself, making of the speech in itself constituted misconduct as defined in the judges, वो पूरा नाम लिख दीजिए, code of conduct. ठीक है? Anything else you want to add?
Sir, in addition to response to these questions, I may kindly be allowed to give the propositions, my propositions.
हमने लिखा amongst others, वो बाकी आप जो मर्जी लिखना चाहें, मगर ये चीजें अटेंड कर लें. अच्छा, full stop. हाँ, precedents भी दे दीजिएगा. हमें लिखने की जरूरत तो नहीं है ना?
Everything. ठीक है. Comprehensive.
So these three you attend to. The rest, whatever you want to add, we are not stopping you. But just keep it sort of more precise. It shouldn't be legal drafting. It should be point.
Thank
you. Thank you very much. It's been a learning experience also for us. जो ख्वाजा साहब, अच्छा हाँ, कितने within how much time to be given आपको?
I think two weeks. If your lordship is
हाँ, 3 हफ्ते दे दें. नहीं, legal issues है ना.
Quite right.
You know, we don't want to say something ना. अब इतना वक्त गुजर गया तो 1-2 हफ्ते अगर वो खान साहब नाराज ना हो कि 3 हफ्ते अब दे दिया. ठीक है, खान साहब 3 हफ्ते ठीक है? 3 हफ्ते ठीक है?
सर 2 हफ्ते ही काफी होंगे सर.
तो ख्वाजा साहब 3 मांग रहे हैं, 3 कर लें. वैसे भी ये इलेक्शन वाला हफ्ता तीसरा हो जाएगा ना फिर.
ठीक.
हाँ, तो ये इलेक्शन के बाद ही जाएगा मेरे ख्याल में. अच्छा, इसमें लिखे कंसाइज स्टेटमेंट्स टू बी फाइल्ड विद इन 3 weeks. In case after judgment is reserved, however, in case after examining the concise statements and the available record, a further hearing is required, the court will convene. We don't know what you're going to say, and some of the things I have not read that were filed today and yesterday. Sure.
Mathura was attacked again and again and again. So nothing has survived, and what has survived is by accident.
Okay.
In none of the cases did the Eidgah party win.
I see.
And the court also told them that you're behaving like hardened litigants when you're going on filing case after case, when we've told you that it is You have no locus standi in the matter. When the Allahabad High Court asked the Muslim party, please show us one bit of evidence of your presence for 300 years, where is your voice? We don't get anything. But on the TV channels, when this case came into the limelight last year, they interviewed many ordinary Muslims and they said, why are you raking this up now? 1968 mein to agreement ho gaya hai.
Okay. Welcome back. It's great to see you all again. The following is a conversation with Padma Shri awardee Dr. Meenakshi Jain. Dr. Jain is a noted Indian political scientist and historian. She is the author of many books, many very impactful books, and she's one of the most relevant and impactful historians in India today. In this conversation, we discuss the case of the Ram Janmabhoomi issue, the Krishna Janmabhoomi, and various other relevant issues that are relevant to the work that she does. So enjoy the conversation and don't forget to like and subscribe. Meenakshi Jain ji, welcome back to the Abhijit Chawla podcast.
Thank you for having me.
It is such a pleasure to have you, ma'am, and a privilege as well.
Privilege for me too.
Thank you, ma'am. Thank you, ma'am. So the last time we had discussed Sati, we did a virtual podcast. Yes. It's finally great to have you face to face.
Yeah, me too.
And I would like to discuss, I would like to learn from you about a number of things. So for example, I am not really well versed in medieval Indian history. I have not really studied the Ram Janmabhoomi case, the Krishna Janmabhoomi case. It's painful. So that's why I've kept away from it. But I would, and you have been instrumental through your work, through your research, in fortifying the case, in providing the evidence that led to the court judgment in favor of the Ram Janmabhoomi trust and the Hindus. So I would like to learn about the history of this entire matter, the temple, the history behind it, and the court case and how it was cracked from you. So could you please?
Before I begin discussing the Ram Mandir case,
yes,